All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 28th, 2024. We have 15 bills on the docket, and we are going to start off with Senate Bill 826. So we'll go first.
Last bill last night, first bill today. Whenever you're ready, Mr. Chairman.
All right, good afternoon, Judicial Proceedings Committee. Senator Smith here, here to enter into the record Senate Bill 826, the vehicle laws, bicycles, operations at intersections. Under Maryland's current law, Maryland bicyclists must abide by the same traffic guidelines as drivers, including coming to a complete stop at a stop sign. And I'm going to have a video here that outlines this whole process and why this bill, the simple fix, will enhance bicycle safety in the state of Maryland. In Maryland, approximately 40% of cycling accidents or accident injuries and 19% of cycling fatalities occurred while bicyclists were actually crossing intersections. So right now you have to stop completely at the stop sign and then proceed forward. What this bill does is allow for a bicyclist to treat the stop sign as a yield sign. So you can have increased visibility and stability for the bicyclist, but also so that the cars can see the bicyclist because it's moving. And also you remove yourself from that section of danger in the intersection more quickly. And you'll see a video that kind of illustrates this more clearly than I can through this testimony. So that's essentially the bill. This bill has actually been passed. This exact bill has been passed in 11 states. The first of which was in 1982. Idaho passed this bill, and they saw a 14.5% reduction in bicycle injuries from bicycle accidents in the year following its enactment. Most recently, I think it's Delaware, you may correct me, in 2017, and a year within its enactment, they saw a 23% reduction in crashes. So that's essentially the bill. I want to play the video with your indulgence, Mr. Vice Chair, and then I'll stand for questions.
Jed Weeks here with Bike More to talk to you about the bicycle safety yield. As a bicyclist coming...
Let me pause it and turn the volume up real quick.
To a full stop at an intersection can cause unpredictability and instability. It also doubles the amount of time it takes to get through the intersection. This often leads to drivers doing irrational things next to bicyclists. It's much safer to yield and proceed cautiously through the intersection. With the safety yield, a bicyclist can maintain their momentum. That means as they approach the stop sign, they can slow, but still move forward. Look in all directions to ensure the coast is clear, and then proceed through the intersection. That forward momentum allows them to keep looking in both directions without losing balance. Once again, we'll compare the safety yield to a full stop. In the full stop, as I approach the intersection, I must stop the bicycle and put my feet on the ground. This makes me lose all of my momentum. After I look both ways and relaunch my bicycle, I have to keep my face forward to maintain balance and momentum while speeding up. This prevents me from double checking the intersection as I cross. If I tried to, I might fall over. With the safety yield, I can approach the intersection, slow but maintain my forward momentum, look both ways, and keep looking both ways as I cross the intersection, because my forward momentum allows me to maintain my balance. The safety yield is currently permitted in 11 states and the District of Columbia. This includes regions that are both more urban, more rural, and more suburban than any region in Maryland. Jed Weeks here with
All right, and so under the bill's language, you'd have to come, you'd have to yield, but you'd have to slow down to a reasonable rate. You still have to yield to any vehicle in the intersection, any approaching vehicle on the other highway that's near enough to the intersection that it poses an immediate danger. And it only applies to intersections of a highway where there are 2 or fewer lanes. The bill does not apply to stoplights or override any of the other explicitly stated guidance that's in the statute, which I have here accessible for you if you have questions. So with that, Mr. Vice Chair, members of the committee, I'll rest. We'll have one more witness come up, and I'd ask the committee for a favorable report, and I'll stand for questions.
Thank you, Chair Smith, for sponsoring the bill. Vice Chair Waldstreicher, members of the committee. My name is John Corrin, bicycle advocates for Annapolis and Anne Arundel County, but today representing a broad coalition of advocates from across the state of Maryland. We know that this bill is counterintuitive to drivers who don't also bike on the roads. We know there's a concern about, does this mean cyclists can blow through the intersection? It does not. It means a full-on yield, as if there was a yield sign there. We know there are concerns about pedestrians. Cyclists are already required under Maryland statute, just as drivers are, to yield to any pedestrians. So we already have that requirement. And in fact, we often advocate on behalf of pedestrians. We know there are concerns about right-of-way. How does this affect right-of-way? The boulevard rule still applies. The drivers passing on the main road still have the right-of-way, just as they do with a stop sign or a yield sign. There have been questions raised about liability. It would be no different if there were a crash where a driver approaching a yield sign crashed with a driver on the crossroad. How would liability be apportioned? It would be no different with a cyclist in this situation having a duty to yield. So we ask you to think about this through cyclists' eyes. All we want to do is get across the intersection at the safest possible time while it's clear and as quickly and reliably as possible. Oftentimes when cyclists are starting from a standing start, they're a little wobbly and it's going to take them longer to get across. This is especially important with approaching trucks or trailers because of their weight have a longer time to stop or slow. This will get us clear quicker. We hope you'll view this favorably. Thank you.
Thank you. We have some questions. The order in which I saw it was Senator McKay, Senator Folden, Senator West. So let's do it in that order. Senator McKay.
May I sponsor the bill, please?
Yes,
sir. So how do you educate these drivers of automobiles that are going to see this as unsafe riding as a bicyclist? The gentleman had mentioned about a trailer taking a little bit longer time to get their momentum going across. If we're going to share the road, shouldn't we share the road under the same rules? I just know that as a driver who has bicyclists, to me, it's very erratic of what they're going to do, and to just allow them to pause. And I understand getting them across the intersection as quickly as possible, but to me, you're creating more of a problem than it being a pause. And some of the testimony where I could almost apply that to somebody in an automobile. Why don't they just slow down and just make it a yield if you don't see anybody and just keep on going? So I don't know, how do we get around educating the public as a whole? I understand the bicyclists, they will probably understand, but how do we get the whole?
It's all of the other, duties of care apply. This bill really only applies to this specific instance for a bicyclist. And so a driver would be adhering to all the normal traffic laws that are already on the books. As for the incident of the trailer, I think getting the bicyclist, and you can speak more of this than I can, but getting the bicyclist through the intersection more quickly is actually safer than having someone kind of stop and then regenerate momentum. So that's the argument there. And what was the third question?
I'm not exactly sure.
No,
I
I hear you.
my biggest concern
Is driver education?
is driver education and understanding that the rules of the road should be the rules of the road, not be for the rules of the road for a few. And
You can come on up.
It's okay. Thanks for the question. In Maryland statute, cyclists are required to adhere to all of the rules of the road as drivers, unless specified otherwise. And there are a handful of exceptions. One would be staying all the way to the right when unless you're in the clear and not impeding traffic. There's some conditions where you can go take the lane. Another is utilizing the shoulder. There's a case where drivers are permitted to cross a double yellow line in order to safely pass a cyclist. So there are a handful of exceptions. And because a person on a bike has better sight lines, no blind spots, the whole physics of riding a bike are completely different from a driver. And a person on a bike is not a threat. It, is not a threat to others the way somebody in a vehicle is. So there are a handful of exceptions. Drivers and cyclists both need to be aware of those exceptions. We're working with MDOT and with MVA to get more of that into the driver's manual and onto the driver's test so that both are educated.
I know that one of the ways of sharing the road was putting signage up. I'm not advocating for more signage because I think we have literally littered the amount of signage when it's especially a bike lane. Come to the city of Cumberland and it is so confusing already. We have so many one-way streets as it is, and then to have this added to it. So please, if you figure this out from an education standpoint, please don't put up any more signs.
Okay.
But thank you.
Thank you.
Senator Folden is next. Please, Senator Folden.
Mr. Chair. Mr. Chairman, Senator, I don't care who answers this, but mine is pretty similar to what, the senator from Western Maryland was saying, but the rules of the road are paramount. They're very clear and they're a requirement to follow said rules. We already have created carve-outs for pedestrian cyclists, pedicyclists. The problem is that we keep changing them and we create these points of conflict, and pedicyclists pay nothing into the TTF, the Transportation Trust Fund. They pay nothing for highway user revenues. There's nothing going that, but we're requiring now that we want to expand the footprint of the roadways to the same subsurface standards and everything. So there's a cost associated with having cyclists in conflict with vehicles that are in transport. That's one. The rules of the road don't change though. So, you brought up like stoplights. I can tell you that many cyclists that I've seen do not follow the rules of the road. They're not as far to the right as possible. They feel that they have strict ownership of the lane. That's a misnomer. They come up to stoplights. When I'm in Baltimore City, I'll see pedicyclists come up to a stoplight. They don't want to stop. They'll take the crosswalk perpendicular to the cars that are stopped at the stoplight, and they'll ride up through everybody, go across, and then they'll go up on the curb and continue across the other way to violate the traffic law. So this is a violation. It is against the law to purposely avoid a traffic control device for every other motorist. But once again, we're saying, well, now they want to be a pedestrian. They don't want to be a pedicyclist. They want to stay in the crosswalk. This is a common occurrence. So, and I see this in areas where it is clearly safer and their responsibility to stop, because a lot of streets are lined with cars. We have sight distance issues. You brought up, the physics versus responsibility of things. And the physics is what it is. You're propelling a bicycle through your own force, right? But if they're allowed to just drift through a stop sign, yield, but drift through it, or if there's a point of conflict that occurs, by this law, you're allowing them to say, oh, well, I didn't see that guy already had gone to the stop sign and they ran into me, so it's their fault. We're creating a new carve-out that is going to create more potential points of conflict, not less, because if you stop, you have to stop and clear safely. The wobble thing, I don't know why that's even being brought up. Because most people that are riding on the roadways are experienced cyclists. A lot of them. So can you comment on the physics versus the responsibility part and the wobble? Because I'm just totally blown away as to how that even applies.
Sure, you can do that, but I also, I mean, just to both senators, go ahead and respond to that, but then I do want to, I want to read something into the record from MDOT, because they can't take affirmative positions on bills like this. They do send letters of information, and I do think some of the information from this neutral source is actually important to be read into the record, so I'll let you respond and then I'll read that.
Okay.
You would come up to the.
Thank you.
Thank you, Senator, and I'll try to get all of the questions as best I can. First, there is nothing that makes my job harder as a bicycle advocate than a cyclist who blows through red lights and some of the other behaviors
Yes,
that you and I both observe.
sure.
But please don't paint all cyclists with that brush, and don't let that inhibit the introduction of a safer practice that allows us to clear intersections at the safest time when it's clear, and it's a yield. You've got to have sight lines. If there's sight obstructions, shrubbery, parked cars, what have you, you have to stop to get sight lines, then you have to stop. Even under this bill, it's a full-on yield. It's as if a driver approached a yield sign. With regard to the wobble, I would suggest that at trail crossings or sidewalk crossings, where you're going to have more recreational cyclists who are less adept, the startup is wobbly and is slower. And so the whole idea here, clear the intersection while it's clear, no oncoming traffic, and get cleared of the intersection quicker. That's a benefit, safety benefit to cyclists, and it's a traffic benefit, a kind of a throughput benefit to drivers if we get through quicker.
I appreciate that, sir. I mean, so thank you for your answer. But again, it goes back to points of conflict that are there by a mode of conveyance that already has its own areas that they're not following the law now. Many.
Some.
And I see experienced riders. They don't stop for stop signs. Like in the groups that I see riding, they're just going.
So do I.
Correct. They all do.
No, not they all. Please.
Okay.
We don't say they all are on all the drivers are on their phones or all the drivers are speeding, but many do.
Okay. So it's just counterintuitive to me that we allow for the other motorists to expect someone at a four-way stop that is listed as a four-way stop to then see someone drift through. So that's one issue. And then the other is that, they're not going to be expecting them to stop. It'll be a yield. But in my experience and what I've seen is there's no requirement for any bicyclist, even though it's a mode of conveyance that has enforceable standards in law, to have any insurance either. So we're creating an opportunity for issues to come about that there could be points of conflict that could have damage to someone's vehicle who was there legally, but the bicyclist is in the intersection, they hit them, causes damage to their car, but the bicyclist now isn't required to have insurance, and we still have a driver with damage to their vehicle. So I just have these concerns. There's many of them, but changing the rules of the roadway, especially at critical stopping points, is not a good solution.
Senator, the last thing I'll say is it's a very, very high bar to get the National Highway Traffic Safety Administration and MDOT to issue written documents that support this as a safer practice. And you have in the testimony both.
Well, they don't support it. It's a letter of.
I do want to read that into the record.
Yeah, let's let the chairman
Yeah,
kind of
so-
read this
so-
in.
No, I appreciate that. And look, I have a bicycle. I'm teaching my daughter how to ride her bike now. I got a new bike for Christmas. So, I'm on the roads a little bit more than I have usually been in the last couple of years. So, I'm glad we have actual folks here that are, engaged in this activity every day. And I have obviously my constituency, a lot of folks that bike around District 20. So I would not do something if I didn't think that it was safe and kind of independently validated by folks that I trust to make sure that we're all safe. And so that's why I thought this MDOT and NHTSA's letter, not of support, but of information,
Yes.
was important, but because it's persuasive, and I want to read a little bit of that. And then we have Mr. Vice Chair Seth Grimes is signed up to testify, and he just got here. So I'd love for him to have an opportunity to testify as well. But so this bill encourages more people to bicycle by empowering vulnerable road users to make decisions that protect them from injury. The bicyclist stop as yield fact sheet issued by NHTSA in March of 2022 contends that based on the current research and data available, these laws showed added safety benefits for bicyclists in states where they have been evaluated and may positively affect the environment, traffic, and transportation. The stop as yield measure is an attractive approach for improving safety because it provides a high safety benefit at no cost. And then farther down, based on this experience, the NHTSA has issued guidance to support the adoption of such laws, noting that the practice allows bicyclists to maintain a safe but cautionary momentum through an intersection, thereby allowing them to better mitigate risks to their advantage, to increase their visibility to drivers, and to reduce their exposure. So it's not a letter of support of information, but I thought, as you've mentioned, MDOT and NHTSA, pretty high barrier to clear, and I think pretty persuasive information. With that, Mr. Vice Chair, I'd like to have.
Yeah, so I think Mr. Schneiderman and Mr. Grimes are signed up to testify. Do you want to take them and then Senator West's question?
Sure, yeah. We can do that
Okay, let's do that.
Thank you, and my apology for being late. I am Seth Grimes with the Washington Area Bicyclist Association. Thank you for the opportunity to testify. I'll try to be non-duplicative of what you've heard from Mr. Corin. First, I'll say that I personally worked for 5 years at the National Highway Traffic Safety Administration. That was on the vehicle crash worthiness testing program, smashing cars against barriers and other cars, and so on. That, of course, is a federal agency that gets involved in federal rulemaking and studies and so on. And what we have here is a request for the state of Maryland to do what 11 other states in the District of Columbia have done, which is change the rules of the road at a state level, under state jurisdiction. So you've no doubt heard the safety arguments and so on. I don't know that you've heard that there's an advantage here of making intersections safer for motor vehicles, speeding the flow of traffic through intersections. So there are benefits for motor vehicles as well. We do advocate at the Washington Area Bicyclist Association for the creation of separated bicycle infrastructure and intersection improvements for pedestrians and so on. But failing those improvements, it takes a long time to make them and costs a lot of money. We do look for changes that will improve the safety situation, and this is one such. So I will stop there and just add that our organization, which has over 1,200 Maryland members, would love to see you enact this bill. Thank you.
Thank you. Franz Schneiderman, Consumer Auto Maryland. I'd like to thank Chairman Smith for bringing this bill and members of the committee for giving the opportunity to address it. You know, I support this bill strongly, both as a road safety advocate and as a cyclist, because I do think that it adds substantially to the safety of cyclists for some of the reasons you've heard. It also makes the roads more hospitable to cyclists. And, you know, it's just vastly more efficient for cyclists to behave this way. And as Senator pointed out, many of them already do. And most of the time that doesn't cause safety problems. 11 states have this rule, and none of them, so far as I'm aware, have reported an increase in crashes. Many of them have reported substantial decreases. Delaware instituted this law in 2017 and found a 23% reduction in crashes at intersection in the 30 months after it was introduced. And just to respond to some of the concerns, I mean, I think this is a fairly limited law. It only allows people to go through the intersection if there's no other traffic in the intersection. If there are other cars in the intersection or near the intersection, they're still required to yield. So they would still be responsible if they behave erratically or unsafely. And you know, so I think you know, some states have established rules that allow you to do this at red lights and go much further than this rule would do. This bill, I think, properly doesn't do that. I think that would be unsafe. You know, the law does contemplate some, even though the general principle is that cyclists are subject to the same rules of the road, there are places where we deviate from that principle for good reason, because cyclists, you know, work differently and they just pose a much smaller threat to the others on the road than cars do. So I think this is a sensible and limited kind of bill. Hope you'll support it. Happy to respond to any questions.
Thank you. Senator West has not asked a question.
No, I haven't. Thank you, Mr. Chair. And I'm trying to be limited in my questions today because I think I was excessive yesterday. So for the sponsor of the bill, if memory serves me correctly, at some time in the past, we either considered or passed a bill that says if a bike rider and a car collide, the car is responsible, the car is liable. Do you remember that?
That may have been the vice chair's bill. Was that the vice chair's bill? No.
Could have been.
Vulnerable road users?
That was my
Yes.
bill, but it didn't apportion liability.
No.
Okay. How would this bill, did we pass that bill?
We did.
We did. Okay. How would this bill interface with that bill?
Yeah, you can answer that question. I don't remember the contents of the vulnerable road user. Do you?
I testified for 4 years on that bill and it was enacted in 2021. And it was recommended by the 2017 Bicycle Safety Task Force. What that bill did, we call it vulnerable road user, vulnerable individual, is it raises the penalties when a driver hits and either kills or seriously injures any vulnerable road user lawfully using the roadway. Vulnerable road user meaning pedestrian, cyclist, motorcyclist, horseback rider, anybody not enclosed in a vehicle. So
Okay.
it only has to do with penalties, and the vulnerable road user has to be lawfully using the roadway. So it's not just any crash.
So if this bill passes, then the vulnerable road user, who would be the biker, would be legally in the middle, would be legally not stopping and would proceed into the intersection. I've got testimony from the Maryland Horse Council here that talks about how horse trailers have a lot of momentum because there's a lot of weight in the horse. They can't stop as quickly as a passenger car could just jam on the brakes and stop. If they did, then the horse in the back of the horse trailer would probably be hurt. So how would the bill we passed several years ago interface with the problem of horse trailers at an intersection coming along? If the horse trailer collided with the biker, would that bill hold? How would that bill deal with the liability that would result?
So a responding law enforcement officer would look at it and have to determine, did the cyclist yield? The cyclist would have a statutory responsibility to yield. If the cyclist was blowing through without yielding and was hit, cyclist error. So cyclists are responsible to yield. I would suggest it would be no different than a driver approaching a yield sign with a thoroughfare across, and there's a crash. Responding officers got to decide: did the driver fail to yield, or was the other guy speeding, or it would be the same situation. So the determination of fault, I think, is no different. It would be as if there's a yield sign there.
Great, thank you. Thanks for your answer.
All right, every senator has asked a question who wished to, so I think we'll return to those who have already asked questions. Perhaps the Senate president was less clear than he should have been, but Senator McKay.
Mr. Chairman, may I, the statement that you had read for the information. It sounded like that letter of information said that the statement said that it'd be definitely safer for cyclists if we were able to do this. Did anywhere in that statement say anything that would be safer to those who drive automobiles?
Better mitigate risks to their advantage, increasing their visibility to drivers. One would suspect that that's a mutually beneficial thing. I'm not sure that drivers specifically were mentioned.
Okay,
But the overall safety proposition is, is enhanced by the enactment
yeah,
of
and
this
that's what I was
bill,
just
in
trying
their
to.
opinion.
It just sound correct. I understand that's safer for cyclists. I'll do some research and figure out how many automobiles we have on the road compared to cyclists and weigh them. Thank you.
Thank you. And back to Senator Fulton.
Thank you, Mr. Chair. So I have a quick follow-up question because we added 2 witnesses after I questioned last time, so I apologize. I wanted to ask the gentleman that worked at NHTSA for a while. So it's nice. Thanks for coming out. I'm glad you made it. But I also worked and did crash reconstruction for 22 years and worked at NHTSA for almost 5 of those.
I did not mean to suggest that I'd worked on bicycle programs there.
That's fair, but it was a pretty powerful statement that you're leading with, that you worked for NHTSA and saw crashes. My point being was, if you saw those crashes, then you saw what happens to the human body when it's impacted by a 3,800-pound projectile, which is basically what a vehicle becomes. Fair?
Yes.
And we're creating these new carve-outs, and this is my concern, is that, we've got a lot of these roads, we're now putting bicycle lanes down the sides of these roads, right? So by vehicle law, you're required to turn from the furthest right part of the roadway if you turn right. But if there's a conflict with a bicyclist who's coming up as this person's slowing and they make that right, who has the responsibility to stop there to avoid that point of conflict?
This bill would not change the legal situation if their bicyclist is supposed to be yielding the right of way. The bicycle
I'm just asking a question about this because it leads me back to the 4-way stop. If you're required by Maryland vehicle law, rules of the road say you have to turn from the farthest right edge of the roadway to conduct a right turn. These bicyclists, we keep making new nuances to the roadway designs. Now we've got, some of these pillars or columns or whatever they are, the little ballards, and then we've got a separate lane. If a vehicle is slowing down to make a right turn and a bicyclist is maintaining a consistent speed but is still behind the vehicle, there is a point of conflict. Laws of physics say they're going to come into contact if one does not take an action. Who is responsible for making a right turn in that point of conflict? Who's responsible to yield? The person that the road was designed for, or the additional road or lane that was added for a bicyclist who is also now created a further right lane that the driver of the said vehicle cannot get into?
Thank you for the question. Yeah, we are discussing a scenario that is separate from this bill, which is when there's separated bicycle infrastructure, which we do strive for. Yeah, we'd like to see signalization and full bicyclist compliance with the rules of the road. A bicyclist who conflicts with a vehicle in the scenario you're discussing is both dangerous to themselves, dangerous to the motor vehicle, and in violation from, as I interpret what you're saying, of the rules of the road where that bicyclist should be yielding.
Well, and that's what I'm getting at, is we've had some bicyclists that have come forward and testified as to certain rules of the road because vehicles are making a right turn, and unfortunately there's a bicyclist there and kills said bicyclist.
I appreciate that scenario.
So
yes.
that scenario is a real scenario. My concern then becomes, now we're creating a point of conflict with another rule of the road that someone could be violating or someone could be in compliance with, and the bicyclist then moves forward is because they're not required to stop, and the said vehicle operator is expecting them to stop, and they proceed forward, and then there's a point of conflict. And by what you all are telling me is that because they're lawfully in the roadway, even though because they yielded, but yield is a far different standard than stop. So law enforcement responding can say, did you stop? Did you yield? Far different standard. So it automatically puts the onus and the liability back on the vehicle operator. So I just point that out because these are complex issues, and I know that we're getting more cyclists, and I'm all about trying to create safe spaces. There's issues with the law as it is in place right now for just the adjacent lanes, let alone trying to add a new nuance. So
we certainly appreciate the concerns you've raised.
Thank you.
Thank you. Seeing no further questions, we'll move to the opposition of the bill. Kimberly Egan. This is in person. Is Ms. Egan here? All right. Seeing that Ms. Egan is not present, that concludes the hearing on Senate Bill 826. Thank you, Mr. Chairman.
I think that.
Thank you.
Thanks. Mr. Vice Chair, I was telling my chief of
Yeah.
staff, she's like, oh, this is an easy bill. And I was like, look, it's always the easy bills that take up like an hour of time in JPR. We deal with the Walter Lomax Act and, home detention monitoring. This is good stuff. All right. Sandy, I'm going to just drop this down. Is that okay? All right. I think we have Senator King is here, right?
Senator King, you are next, and you're welcome to bring up your panel.
Okay. Good, thank you. Thank you for fitting me in here this afternoon. Busy day trying to put everything together. Mr. Chairman and members of the committee, truancy has been an issue in our schools, even when I was on the Board of Education 100 years ago. But the number of students who are truant or chronically absent has grown, and the reasons for their truancy have grown more complex. I am introducing Senate Bill 865, Truancy Reduction and School Reengagement Program legislation, as another way for our school systems to partner with the courts to help our students reengage in school and receive the education they deserve. With me this afternoon, I have my good friend and former colleague, Judge Kathleen Dumais, who is currently sitting as the juvenile delinquency judge in Montgomery County, and Mary Gable, is she here? Who is from MSDE's chronic absenteeism team. And I just wanted to note for you, in 2022, this bill was unanimously passed in the Senate, but it didn't get heard in the House until March 31st, so it did not move. In 2023, this bill unanimously passed the House and was referred to rules in the Senate and on March 20th and never moved. So we're hoping for a better path for it this year. And I would respectfully request a favorable report on Senate Bill 865.
Good afternoon. It's nice to be back to see everyone again. I'm here today on behalf of the judiciary. The judiciary is in support of this bill. I am particularly here to support it and offer my perspective based on my experience sitting on the juvenile court. I have been assigned to this rotation since July. The number of youths that I see every day that simply do not attend school is just astounding. And although this is a generalization, the youth that fail to attend school are often usually involved in more serious crimes by the time they get to me. And their truancy has been longstanding. The scope of the problem staggering. Montgomery County, just for sake of numbers, has over 168,000 students in the schools. And yet 21.4% or 34,161 students qualify as chronically truant and chronically absent. So what does the bill do? The bill will set up it's enabling legislation, number one. No county has to do this, but this would allow counties that are interested, and at the moment, I believe Montgomery County is, and so is Frederick County. But it was initially passed in 2004 as a pilot program. And a large number of counties actually have these programs, specifically Dorchester, Somerset, Wycomico, Worcester, Hartford, Kent, and Prince George's County now operate successfully. The purpose of the bill, as sitting sort of as a problem-solving court, these cases would be referred by the school system to the court. They would not go to the state's attorney's office. They would not go to DJS. I would not, as a sitting juvenile judge, have any ability to find them delinquent or find them a child in need of assistance or order them sheltered or detained in any form whatsoever. The purpose of the program is to have the school system make referrals to the court directly, and that then we would hopefully work with the family as a whole to see if we could provide services to them prior. I can continue. Okay. That's right. So we could direct them to services. This is going to be just one program. Montgomery County is fortunate. We have an excellent program through our state's attorney's office. They are in about 25 middle schools and 1 high school at the moment. In each school, they work with about 8 to 10 students. But if you look at that, then over the course of a year, maybe they work with about 300 students. As I said, in Montgomery County, we have 34,000 students that qualify as chronically absent. So the purpose is, this is just one more possible program that I hope that with this bill passing will enable Montgomery County, as it indicates, as the administrative judge of any circuit court that would sort of move this forward. And I'm certainly very anxious to get it up and running in Montgomery County. Hopefully, we can address some of these kids before they reach the point that they get into a delinquency situation where they're before me, where I do have authority to find them delinquent and perhaps detain them. So I do hope that very favorable report on this, particularly since it's been passed by both bodies, but different years. Hopefully this year will be the key. And again, it's enabling. But the key to this, the complaints that I've sort of heard about the bill is, oh my God, you're taking kids to court and you're taking families to court, and this is awful. Well, it's a voluntary program. If the parents and the kids don't want to come, there is no teeth or sanctions to them not coming. This is just sort of a service that we hope gets kids early on before they're chronically absent. And again, we'll probably start middle schools because that's really where hopefully you can make a difference. Although I obviously have a lot of high school kids that are before me and I would love to be able to talk to them. But again, by the time they get to me in juvenile court, they've been absent for a really long time. And so we want to get it early on. All right, thank you. Happy to answer questions once the State Board of Education has spoken.
Good afternoon, and thank you for the invitation. I appreciate Chair Smith inviting me and certainly Senator Kelly. I'm Mary Gable. I'm Assistant State Superintendent with the Maryland State Department of Education. And as been mentioned by Senator Kelly, attendance, chronic absenteeism, truancy are all very important issues that schools and school systems face across the state. So we appreciate being part of the legislature to support legislation and as one of the tools to assist students. This bill in particular is about students who are truant. Students who are truant are students who are illegally absent. They can be absent for more than 8 days in a quarter, 15 days in a semester, or 20 days in a school year. In addition, we have students who are chronically absent, and those are students that are absent 10% or more of days. Chronic absenteeism includes all types of absences. They can be legal, they can be legal or not legal absences. But the important thing is that there have to be many tools to address families to support them. What this does is it unites the family, the school, and the court for those students who have been truant. But there is a need to look at the data, but data is not the only thing. There has to be more effective interventions and nuanced approaches to dealing with our students to improve attendance. We have to identify early warning signs. We have students in very young grades, early grades, that begin to show patterns of absenteeism. But families, especially families that are in poverty, have different needs than other families that are not. There may be multiple reasons why the student is not going to school. It could be because they're babysitting or they have to work and other measures. But I will stop there. We appreciate the opportunity to be here. Thank you so much for this initiative to help our students.
Excellent. Thank you very much. Questions from the committee? Well, I do have a question then for Judge Dumais, because I know it'll come up in the opposition panel. So the voluntary nature of this program. So engagement is voluntary, but once you're enrolled, once you're in the program, then it seems as though the bill gives you the ability to say, hey, you got to go to summer school, you got to go to a credit granting things, you got to go to that substance abuse program. But then it says issue any other order that the court determines is appropriate to achieve the purposes specified in sections 3(8)(c) B of this subtitle. And so just want to give you an opportunity to unpack that a little bit in terms of, if someone doesn't comply with an order to attend this, that, or the other program, then it seems as though there's an open door here to issue any other order.
Well, I'll tell you what
Yeah.
has been happening,
Yeah.
certainly in Prince George's County, and as far as I know, in the Eastern Shore counties. What usually happens is if they're not going to participate in the program, then they're let go. I mean, the Prince George's County program has been in operation for about 14 years. It's run by one particular magistrate, Magistrate Althea Stewart Jones. And she is amazing. I've heard her speak about this. So she will talk about how, there are kids that will engage and families that will engage. And then there are families and kids that won't. And there's really no sanction. It's just, they're not going to graduate. I mean, in Prince George's County, and I know in the Eastern Shore counties, they actually have graduation ceremonies where once the kids have met certain markers. But if that piece is a problem and needs to be tweaked, then we can tweak that and I'll take a look at it again. But the idea behind this is not that there is a sanction at the end of it. It's a voluntary program. You participate or you don't. But at least in talking to Magistrate Althea Stewart Jones, she says many families welcome this. They didn't know where to go. They didn't know what services would or wouldn't be available. And even just setting markers for the kids and getting to the root of why this truancy is occurring or the absenteeism is occurring. That's really the point. Like I said, more tools in the toolbox. Not every county is going to do it. But I know that Frederick County is very interested and has a local bill that's over in the House. And I know that there are many in Montgomery County that are interested in seeing this path go forward.
No, I appreciate that. Yeah, just wanted to clarify because I know
Yes,
it's coming
I
up,
understand.
the court order, and then,
Yeah.
Can there be a contempt of court if you don't follow I know that in practice it hasn't happened
Right.
in Prince George's County, but could it happen?
All right. We're
under
going
the
to take a
language
look
bill?
at that section and maybe we'll have an amendment that'll assuage some of the concerns. And
Senator
I knew I
James.
talked too long because Senator West has also got his light on.
Senator James is first, then Senator West.
No, I'm teasing.
Thank you, Senator. I would have asked a question earlier, but I couldn't find it in the fiscal note, but I guess the old bill, I don't know if the current bill does this. It will repeal the current truancy, does it?
When it
Repeal the
passed-
truancy reduction pilot program operating in mine and many other counties. Is that what the bill does this year or not?
No, it does
Okay.
not repeal anything.
So, and then I noticed that because we do have this program and it is in my counties along with many others, I don't know where those counties stand. And I understand this is an augmentation, another way to go.
Right.
But I guess I'm not understanding why we're not getting feedback from these pilot programs, what's working and what's not, and craft a bill that way.
We do have some information in the judiciary's testimony, whatever, and I'm certainly happy to, I know there are 2 counties in particular on the Eastern Shore that I'm happy to provide
I guess what I'm
information.
saying.
Because I do have people here that are, in charge of the problem-solving courts.
Do you have is somebody from Harford County represented here?
I don't think I have somebody from Harford County, but we will get the data and get it to you.
So is this bill coming out of recommendations from the pilot programs that are
Yes.
here, obviously, to give us information?
Yeah.
So is there a report?
There is no report, but the bill does provide that there will be a report in the future and that there will have to be reports given to the General Assembly on an annual basis so that we do then have the data.
So I'm just trying to understand this. So where is this recommendation for this bill? Where would I find that?
I don't think it's really just that the programs have been successful and that Montgomery County expressed an interest. Frederick County expressed an interest. Washington County has expressed an interest. So the question is, we already have so many counties. Why don't we make it statewide? And again, it's enabling. Counties don't have to do it.
I know, Judge, you're exacting and I'm exacting. I just want to make sure when I call Harford County, I don't misstate what you're saying, which
Okay.
is, guess what? This came out of the work you're doing with the pilot program. And I'm
Yes.
hearing that would not be accurate, just that there's some other counties that have been doing the pilot program or not and would like this bill. But this is not emanating out of the collective consensus of this pilot program that exists
There is
now.
not a collective consensus, but these are successful programs and we want to build on it. That's the only distinction.
I am not saying they're not
I know you're
successful,
not.
so I'm not
I
sure
know.
why you had to add that. I'm
Mhm.
just trying to figure out where this is coming from. Thank you.
Okay.
Senator James, so in the statute, there's on or before November 1st of each year, the Chief Justice of the Supreme Court of Maryland shall report to the General Assembly in accordance with the state government article. So I will make sure you get that report from 2023. I don't know what's in it. I mean, I haven't read it, but it may answer some of your questions.
Well, I just didn't want to, I'm going to call Harford County and ask them about this, and I don't want to misstate your testimony.
All right, I'm printing it out and sending it to you right now.
Thank you.
All right. Senator West.
Thank you, Mr. Chair. I love this bill. I think the bill is very important.
Well, thank you.
We had a briefing just before we started hearing legislation in this session. And the most salient fact that's come to my attention ever since I came down here on opening day was the testimony of Dr. Webster from Johns Hopkins University. He did a study of youth who were in shock trauma. He studied 70 young people in shock trauma in downtown Baltimore. And the common denominator, 69 of the 70 young people who had been shot and injured in shock trauma, 69 of them were high school dropouts.
Right.
And they dropped out because they had been chronically absent before that and then concluded that they would never graduate. So why keep going to school? So this program is extremely important. Having said that, there have been statements that the program is voluntary. I can't find anything about voluntariness in the legislation.
It just means that the school system refers the families and the child to the court.
Okay.
And then we invite them to come in and to work through the program. That's how it's worked in Prince George's and the other counties.
So, but once the petition is filed, as I read it, there's a process that's established, and there is going to be an adjudicatory hearing, and then a disposition hearing to decide what happens. And the court will enter an order
Right.
ordering the child to do whatever.
To do whatever, to participate in certain programs.
So what I don't see here, and I think the chair of the committee was getting at this a bit, was suppose the child doesn't comply with the order. What are the repercussions? And I don't find that in the bill.
And in the current programs, there really aren't any, but I will take a look at that and see if we can clarify that so that, again, it's very clear that this is a voluntary program. It's, this is a service that we're trying to offer to sort of see if we can help some families. I mean, seeing some of these, I was just talking to a state's attorney from Montgomery County about one of the kids that's not necessarily about truancy, but how the parents went to the state's attorney's office. And many times parents, when I'm sitting in juvenile, say, I have been everywhere trying to find services. I don't know where to go. No one will direct me. This is one way. And again, we're not talking about a lot of kids. I'm not expecting to have 34,000 new cases. I'm expecting.
I bet you wish you had 34,000 new cases.
Well, if I did, I'd need about 200 more judges. So we know that's not happening. No problem. But at the same time, if we can affect, as I said, the state's attorney's office is handling around 300 students a year. If this particular program can handle another 300, or maybe more, depending on how many judges we can get involved in this problem solving court, great. And again, I know, for instance, someone who's very interested in it is our former colleague, Judge Brett Wilson. From Washington County is very interested in having it. And I know that Frederick County is very interested in it. And each program's a little bit different.
Brett Wilson is a good friend of a lot of us here.
I agree.
A final statement is, if you, in administering this program, discover there are problems, especially with holding students to account to do what the court ordered them to do, come back to us.
I will.
And next year we'll try to beef this program up to make sure that everything ties together.
Absolutely.
Thanks.
And just so it's also clear, the way I would probably start it in Montgomery County, we would probably put together a work group of stakeholders, from across the services, as well as, other judges that have been involved in juvenile, that obviously the Montgomery County Department of Justice, and we'll sit down and we'll work through the details before we get set up. So. Okay. Thank you.
All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel. Megan Berger and Frank Panella. Hey, how are you? Welcome.
Can I start? Okay. Good afternoon, Mr. Chair and Vice Chair and members of the committee. My name is Megan Berger. I'm the legal director at Disability Rights Maryland, the state's protection and advocacy agency. We're congressionally mandated to advance and defend the civil rights of individuals with disabilities. I'm also here on behalf of the Coalition to Reform School Discipline. With our experience representing youth throughout the state, we urge the committee to issue an unfavorable report. The committee has the coalition's one-pager and written testimony, which I won't repeat at length here, but I wanted to highlight a few points. Truancy is due to a complex array of factors, including unmet or unidentified academic needs, student discipline, and lack of appropriate social emotional behaviors and supports. The coalition represents students with a wide range of academic and mental health needs. Many of our clients have experienced years of school failure, and yet are never referred for an evaluation to determine if they have a disability impacting their educational performance. The relationship between school attendance and academic achievement is well documented, and students with disabilities are at a greater risk for absenteeism. According to the Maryland Report Card on MSDE's website, Black students with disabilities represented an absenteeism rate of 45.6% as compared to all students with disabilities in 2023. The IEP team is the appropriate forum to address those students' needs along with community supports. Rather than expanding court involvement, we urge the state and school systems to focus on evidence-based interventions that are not punitive and center on prevention, including school-wide strategies that improve school climate and school engagement, as well as individual student-focused interventions, such as special education services and student support services. Rather than pulling young people into a court, which is adversarial by nature, we need to figure out what these students need where they are, which is in the schools. This is why we support more holistic and informal truancy programs, such as the one run by the University of Baltimore School of Law Center for Children and Families. We appreciate the judiciary's interest in helping to address truancy, but we don't believe expanding the engagement on this issue is the answer. Thank you.
Thank you, Ms. Berger. Mr. Patinella.
Good afternoon, Mr. Vice Chair, members of the committee. Thank you for the opportunity. My name is Frank Patinella, Senior Policy Advocate for the ACLU of Maryland. I want to thank the supporters of this bill because we agree on the intent, but we are opposing the bill for a few reasons. As noted in my written testimony, 2011 DLS report recommended that expansion of truancy courts should be predicated on more data and study. To my knowledge, there has not been a follow-up study since that time to justify that expanding truancy courts is the most effective step our state can take to address truancy. We already know that more court involvement leads to more entanglement with the legal system. My last point is about the $4 billion blueprint plan and the very informative briefing on truancy and absenteeism that this committee held just last month on January 18th. The briefing featured a number of experts that talked about the many stressors that contribute to Maryland's truancy rate and highlighted best practices at the school level for addressing truancy. What I appreciated most was the presentation given by the principal of Woodbridge Elementary School in Baltimore County, Miss Lori Phelps. She went into detail about all of the strategies she and her staff used to reduce absenteeism from a staggering 28% to 9.2% over a one-year period. Her approach involves closely tracking and analyzing patterns of absenteeism among individual students, building strong relationships, effective communication with families, connecting families with services and community-based partners, improving the overall social environment, and much more. This is a model program, but how many schools are doing this? Shouldn't we work to scale up this model and make sure schools are being held accountable for implementing best practices on truancy? If we establish more truancy courts first, it takes the onus off of our education system to operationalize these practices that have been proven to be effective. And this aligns well with the blueprint plan, which we thank you for passing. A lot of money for community schools and 110 million was just awarded to the Consortium for Community Support. So for these reasons, we ask for an unfavorable report. Thank you.
Questions for this panel? All right, seeing no questions, that completes the hearing for this bill. We'll now move to Senator McKay, Senate Bill 857. Senator McKay, you're welcome to bring your panel.
Welcome, sir. Well, Mr. Chairman, members of the committee, it's just not another pretty face. But is that what that is? Thank you very much. Got you in the right frame of mind. Senate Bill 857 creates the following: an off-highway recreational vehicle trail fund. And it also establishes an off-highway recreational vehicle recreational oversight board to advise the Secretary of Natural Resources on certain matters and review and approve certain expenditures. Now, according to the Federal Bureau of Economic Analysis, motorcycling or ATVing ranks number 4 to the economic impact to the outdoor recreational economy in Maryland, and is nearly even with hiking and camping and biking when those two categories are combined. This means OHV overrepresents economic impacts while it underrepresents the availability access to our public spaces. Motorized recreation is the fastest growing form of recreation in the country since COVID. There are multiple use trails, even here in Maryland, demonstrated out in Garrett County at the Wolf Den State Run Park, with known users conflicts to date, about 10,000 plus visitors to the park. Why creation of a board? The reason is to streamline accountability. The end users end up getting a direct input into what they see, what they like. And it also gives the groups to give similar boards. Now, we'll also make sure that we prevent funds from going into the wrong priorities. Users feel that trail development and maintenance outweigh the perceived demand and higher quality campground amenities and vice versa. This also helps keep priorities within line of the experience of that and expectations. And the bill does take some money out of MDOT, and there is a concern with that. We're willing and to work with MDOT and maybe phase in some of the funding. But at the end of the day, I ask for a favorable report for Senate Bill 857, and I would like to call on my panel, and then we actually have one in the Zoom land who'd like to speak, Mr. Chairman. You want James to go first?
I think traditionally we allow the in-person folks to go first. I think that would be preferable for the committee.
Yes, sir.
Thank you.
Please, Steve. Yeah, 2 minutes. Yes, sir.
Good afternoon. My name is Steve Salisbury. I'm happy and proud to be here today to represent the Maryland Off-Highway Vehicle Alliance, informally known as MDOHVA, to ask for your support of SB 857. For the past 10 years, the MDOHVA has worked with the Maryland Department of Natural Resources to create ORV trails and facilities like those at Wolf Den Run State Park, and to have the ORV title tax funds used by the DNR to support them. Maryland ORV title funds should be used to develop infrastructure like ORV restrooms, parking lots, and campgrounds, and to ensure they all have accessibility compliant features. Enactment of SB 857 will allow those things to occur without straining the overall DNR budget. MDOHVA leadership knows firsthand that ORV enthusiasts want to be more involved in the Maryland ORV access to decisions and oversight of the funds they contribute. Your passage of SB 857 will facilitate that. Finally, this bill will allow the Maryland DNR to lease and manage ORV trails on private lands for public use. State land management agencies nationally employ similar models. The state of Maine currently manages roughly 6,500 ORV trail miles, the vast majority of which are on private property of almost 3,000 landowners. The states of Vermont, New Hampshire, West Virginia, and others also manage ORV trails on private land for public use. Thank you for the opportunity to testify. The Maryland Off-Highway Vehicle Alliance and I look forward to your vote in favor of SB 857. Thank you.
Thank you. Mr. Ratino. So Mr. Ratino, I see you are not muted, but we cannot hear you. So we're gonna look on our end and see if we have anything, and if there's anything on your end. Okay, Mr. Ratina, I'm being told it's not on our end. I don't know if you're on, have a Bluetooth. All right, I apologize, Mr. Ratina. We cannot hear you. We're gonna come back to you. We're gonna move on. You're the last witness on this bill. We're gonna come back to you if we are able to resolve your audio issues, and our apologies. What's that? And yes, and indeed, we have your written testimony as well, but we want you to be able to provide oral testimony if possible. So do we have any questions for the sponsor or Mr. Salisbury?
Yeah.
All right, seeing no questions, we will move on to the next bill, and then Mr. Ratina, we will return to you. Stay online and we will return to you if we're able to take your testimony today. Sen-
Do you want to ask the witness?
Okay, Senator Carter, we heard you would like to do Senate Bill 728. So let's go ahead and take that one if you are amenable.
Thank you, Mr. Chair. So excited to have this bill called now. Before I get started, I just want to ask everybody that's here from Build and everyone else just to stand to be seen by the committee. Such a beautiful sight. We love it when the people come down here to support legislation that's important to them. So I'm just going to get started. We have a long day and a lot of testimony. This super important bill could have a tremendous impact on our multifaceted efforts to have persons re-enter and reintegrate into society post-incarceration by taking the burden of certain unnecessary fees from them. As we know that when people get released, often the quest for employment and housing and just overall things that we take for granted often becomes very burdensome. And so the idea that we charge fees to people that are fighting to get jobs and employment and just put a roof over their heads is rather ill-conceived. Parole supervision fees. This bill is Senate Bill 728, and it seeks to repeal parole supervision fees for mandatory drug and alcohol testing costs because they create significant obstacles to individuals attempting to rebuild their lives post-incarceration. For many, these fees represent an insurmountable barrier to successful reintegration. Requiring individuals to pay for necessary services like drug testing disproportionately affects those already struggling financially, perpetuating cycles of poverty and recidivism. By repealing these requirements, we can foster a more equitable and effective system of reentry and rehabilitation. Removing financial barriers will enable individuals on parole to focus on constructive activities such as securing employment, securing housing, and accessing education and treatment programs. This, in turn, will promote public safety by reducing the likelihood of reoffending and enhancing community stability. These measures, if repealed, will alleviate undue financial burdens on individuals striving to reintegrate into society after incarceration. I'd urge a favorable report. I am going to be short because there's a number of people that enthusiastically wish to testify in support of this bill. I also must point out that I've gotten a number of different notifications from people that the fiscal note is absolutely incorrect, that it incorporated much more than what this bill does, which is parole fees and cost for drug and alcohol testing for people that are on parole post-incarceration. Additional things entertained by the fiscal note are beyond the scope of the bill. And so I expect when it's corrected, the fiscal note will be substantially lower. Any questions? Okay.
My name is Thomas Anderson, and I'm casting my unwavering support behind SB 728 and HB 531, which is poised to repeal both parole and drug and alcohol testing fees. Over the past year, in collaboration with Build and Turnaround Tuesday, we've had the privilege of engaging over 300 returning citizens and their families. Through this interaction, we bear witness of the profound challenges they face upon returning into society. Time and time again, they've been confronted with the crippling impact of parole fees, individuals struggling to pay fees without even having stable housing or employment, individuals fearing going back to prison because of the inability to pay these fees, and the lack of awareness of exemptions and application processes. Also, the accumulation of debt and punitive interests have also created financial burdens. Shortly, you will hear testimony from Alicia Shaw, who has been directly impacted by the status quo. Parole fees have been plaguing our state for decades. 15 years ago, the Brennan Center for Justice conducted a thorough examination yielding critical revelations and highlighted the elimination of parole fees, the ceasing of the 17% interest on accumulating debts, and the fact that these fees did not go towards supporting parole or returning citizens. Yet, despite this recommendation, Maryland continued to be one of the few states in this region that still charges fees. I'm appealing to you to repeal this parole situation because it's not a fiscal matter as much as it is a matter of dignity and compassion. Therefore, I implore you to stand on the side of justice and support these bills. Let us have a resounding message in Maryland that says that we're standing against redeeming, rehabilitating, and unwavering pursuit for fairness and justice. Thank you.
Come on up.
Okay. Hello, everyone. My name is Alicia, and I'm a member of Turnaround Tuesday and Build that trained and supported me to find work at the Johns Hopkins Hospital for the last 6 years. I want to share my experience with the parole fees that add up to over $7,000 that I have to have paid before my parole is concluded. When I was 18, I was convicted and served 16 years at the Maryland Correctional Institution for Women. At my first parole hearing, I was given a 6-month delayed release due to good behavior. I completed all of the programs. I obtained my GED, and I obtained 71 credits towards my bachelor's degree. One day, I hope to have enough money to continue to finish that degree. When I was released from prison in 2018, I met my parole agent, and one of the first things they mentioned was that I had to get a job to pay my parole fees, but they never gave me any advice on how to get one. After serving 16 years, how do I start paying parole fees when I could hardly feed myself. The only money I had was what I had saved, and I was already paying $600+ a month to stay with my sisters in my sister's home that she obtained so I could be on home detention. I mean, yes, I did have a temporary roof over my head, and I could look forward to a hot meal every day, but where was I supposed to get $50 a month? I looked all over Baltimore and finally found a job paying $9.39 an hour. Soon I wouldn't have a place to stay because my sister's lease was almost up. Do you know how much stress this can cause a person that knows how the streets can provide an easy route and take all of those worries away? But I remained diligent because I made a promise to myself and my God, and with that mindset, I was able to figure some things out. I don't take this parole fee lightly because this is my freedom, but I know so many people that don't have the resources or the patience with themselves or the system, so their story might turn out different. I urge you to look at the impact these fees have on the lives of people like myself, because 7 years later, I still have this bill lingering over my head, and it has to be paid before my parole is closed out. However, I strongly support the passage of this bill to end parole fees in Maryland once and for all. Thank you.
Nancy and Rebecca Diller.
All right, Senator, do you want to just do your Zoom, someone joining virtually?
Rebecca Diller.
Yeah, Rebecca.
Yep.
Hey, Rebecca, you're up. Welcome. Hey, Ms. Diller, can you hear us?
Yes, I can. Thank you. Sorry.
Excellent. Welcome.
Thank you. Thank you so much for having me here today. My name is Rebecca Diller. I'm a clinical professor of law at the Benjamin N. Cardozo School of Law in New York. And I'm here today because in 2009, I co-authored a report for the Brennan Center for Justice on Maryland's parole supervision fee, the subtitle of which was called The Barrier to Reentry. And this report was the result of data collection, interviews with people on parole, as well as DPP personnel, and focus groups with people involved in the reentry movement in Maryland. And what we concluded at the time was that the parole supervision fee was a penny-wise, pound-foolish provision that undercut the ability of people seeking to reenter after prison by saddling them with debt and by creating obstacles in their efforts to comply with parole, find jobs, find housing, etc. And I just want to highlight for you some of our key findings, which I believe are still relevant today. At the time, we found that when the fee was initially authorized by the legislature in 1991, the legislature expected that most people on parole would not be able to afford the fee, and therefore it built in exemptions. We found that most people on parole were in fact unemployed and unable to afford the fee, but that the system for granting exemptions was broken. And we found that at the end of their time on parole, only 17% of supervision fees that were assessed were collected. So I believe, I'm not sure if that's indicating that my time is up, but what I understand is that these concerns are still very much in play today. The efforts to improve the exemption system, it doesn't seem have worked. And at this point, as we called for in our report in 2009, the right response is to eliminate the fee entirely.
Excellent. Thank you very much, Ms. Diller. All right, we're going to do, sure, I know you've got another panelist as well. I know Ms. Warnken is here and is it Ms. Jones? Ms. Jones, and then Ms. Rothstein is here as well. So let's do this panel here. Go ahead, we can go ahead and finish Ms. Jones, and then we'll bring up Ms. Morgan and Ms. Rothstein.
Great. Thank you for having this important meeting today. My name is Priya Sarthi Jones. I'm the Deputy Executive Director at the Fines and Fees Justice Center. We are the leading national advocacy organization and the lead in partnership with the ACLU and the Americans for Prosperity in a bipartisan national campaign to end justice fees. SB 728 is an important step in the fight to end regressive taxes in our justice system. While fees have become common practice to try to fund government, as they have become in Maryland, this practice is short-sighted and harmful. It creates undue burdens on individuals, families, and communities. It's costly to the government, and it cuts against important policy goals for those reentering society. The specific fees in this bill seek to eliminate parole fees and those associated with drug and alcohol testing for those on parole are particularly egregious. For people attempting to re-engage in their communities, gain employment, and be valuable members of society after serving time in incarceration, an additional $50 monthly fee that is tied to their freedom creates a tremendous burden to individuals and society at large. Here are some statistics that provide context for who's being charged and paying these fees. In the first few months after incarceration, individuals on supervision earn 53% of the US median wage. After 4 years, only 84 cents on the dollar. In the state of Maryland, that means less than $35,000 a year. What that means is that people cannot pay. And when they do not pay, their parole can be revoked, sending individuals back to prison, further harming their chances of successful reentry and directly harming their families and the communities. And if that's not compelling enough, the fact is you don't collect the money. After nearly 15 years ago, the Brennan study found that only 75% of parole and supervision fees were referred to the Central Collections Unit because only 17% were collected. The state is setting people up to fail, punishing them when they do, and saddling individuals and family with debt that they will never be able to pay. And if this committee needs further convincing, the fact is assessing these fees cuts against public safety in Maryland. Individuals saddled with court debt admit to committing more crimes, even serious crimes, to pay these debts. These fees move supervision officers from their work of being of service to supporting those reentering to turning into debt collectors. I encourage you to provide a favorable vote on this bill. Thank you.
Excellent. Thank you very much. All right, we're going to turn to questions for the committee for this panel, and then we'll move to the next two witnesses. Senator Muse.
Thank you, Mr. Chairman, and our senator here. Just one point of personal privilege and then one question. You have a champion of a senator here. And sometimes when you listen to the media and media reports and even some community leaders or even preachers who never can say a kind word about the work that she's doing here. Her heart is in it. She works for the people. And I want you to know that. Any of you know Park Heights Avenue? Park Heights Avenue. I'm from Park Heights Avenue. And yeah, there we go. What's up, bro? I'm from Park Heights Avenue. And I lived in that neighborhood for a while. I just wanted to put that plug in because often we don't give people their flowers while they smell them. Let me say, I think this is a horrible policy that needs to be changed. Just one question. For a person who's on parole, what and how much does this take out of a pocket, basically, of a person a year or 6 months? I mean, what is that pretty much equivalent to?
You want to take that?
Just something about the
If you want to answer it, come up to the podium. But the young lady that testified said that it was $7,000 out of her pocket, but the bill is specifically the $50 monthly supervision fee plus any fees associated with mandatory drug and alcohol testing. Go ahead.
Okay.
What was your $7,000?
My $7,000 would be is over $7,000 over a period of the years that I have to remain on parole. So it's actually determined by how many years you're on parole. So however many years you're on parole is however many months you have to pay until your parole is concluded. You have to pay $50 a month until it's concluded, and it's not closed out until that fee is paid. And no matter how many accomplishments you've made, how much you volunteer, how much you be of service to the community, if you don't pay that fee by the time your parole is concluded, it could be revoked, and all that you've done since you've been out can be taken away from you because you can be sent back to prison.
Thank you very much. That's a horrible policy, and I'll work with you in any way that we can to make sure this bill passes. Thank all of my Baltimore people. Bobo.
Yes, thank you.
Mr. Chair, I just wanted to ask the young lady about the parole, how much the fees were. So
There-
yours were more than the $50, because $50 a month would be almost 12 years
Yeah,
to get
well,
over $7,000.
yes, mine's is for 14. I had a
Your
30-year sentence. I did 16 and I came home 14 years parole. So over the course of 14 years, I have to pay it over the course of 14 years until it's up.
Okay, thank you.
All right, seeing no further questions, thank you all very much. Ms. Rothstein and Heather, come on up.
Okay. Good afternoon, members of the committee. For the record, Heather Warnken, Executive Director at the Center for Criminal Justice Reform at the University of Baltimore School of Law. Among my roles and responsibilities has also been representing our law school on the Criminal Justice Coordinating Council's Fines and Fees Working Group for Baltimore. So I speak today reflecting on the findings and deliberations of our group's recent work as well. So as you've heard, the reality is most individuals are unable to afford these fees for a variety of reasons. As this committee knows well, formerly incarcerated people face numerous collateral consequences, including significant obstacles to securing employment. Of those who do access jobs, I want to reiterate a stat that Ms. Jones already mentioned, because I think it's worth reiterating. Research indicates that in the first few months, they earn just 53% of the median U.S. worker's wage. Beyond undermining reentry success for that returning individual, I want to emphasize the counterproductive and inhumane impacts of these fees on their loved ones, including their children. The stress of the fees alone can be an enormous burden, causing fear and potentially re-traumatization if their parent were to be reincarcerated for failure to pay. Accumulating fees can also push a family into difficult decisions surrounding paying for necessities such as food and medications while trying to keep up. Unrealistic fees are also unwise from a public safety standpoint, as you've just heard. People who pose little to no public safety risk may be returned to detention, leaving significant costs of unnecessarily incarcerating that person to the state. Despite the resources that the state employs to collect those fees, the collection rate, again, hovers just around 17%. These resources would be better allocated in support of measures that actually prevent crime. We urge a favorable report. Thank you.
Okay, thank you, Chairman Smith, Mr. Vice Chair, and members of the committee. My name is Melissa Rothstein. I am the Chief of External Affairs at the Maryland Office of the Public Defender, and I urge you to issue a favorable report on Senate Bill 728. The collateral consequences of justice involvement are substantial, and the fees and costs imposed can be especially burdensome. Whether released on parole or subject to monitoring, that includes drug and alcohol testing, individuals who are returning home rarely have the income to cover these expenses. At best, it takes money away from at best, it takes money away from needed expenses like food, clothing, and rent, and impacts the entire family's well-being. When this is impossible, it results in spiraling debt and technical violations that can result in unnecessary incarceration. It is important to note that the fees and costs to be repealed by this bill disproportionately impact Black and Brown individuals from marginalized communities who are both overrepresented in the criminal justice system and more likely to be poor. They are indeed a regressive tax that increases racial disparities. The state fees lodged against justice-involved individuals used to include an assessment for public defender services. In 2017, after a notice and comment period, we repealed the COMAR regulation authorizing the fee, finding that it was inequitable and inefficient. Our clients, who constitute the majority of defendants, have been certified as indigent and often struggle to meet basic living expenses. Overwhelmingly, they were unable to make this payment. We were only able to collect approximately 10% of the fees imposed. The remaining 90% went to central collections, where they often still could not be collected, but increased individual debt with the interest and fees imposed and impacted credit ratings, making it harder for individuals to secure housing and needed loans. And I would say to Senator Carter's point earlier with respect to the fiscal note, I don't believe it actually accounted for the fact that the fees generally won't be able to be paid. An individual on parole has served their time and needs financial stability to effectively reintegrate in the community. Imposing costs for parole supervision or drug testing make this more difficult. We thank Senator Carter for bringing this important bill and urge the committee to issue a favorable report.
Excellent. Thank you very much. Questions from the committee? Thank you for the note on the fiscal note, though. It's important. All right. Thank you both very much. Thank you. It's good to see you both. With that, that will end the hearing for Senate Bill 728. We'll now move on to Senate Bill 890.
Yeah.
Okay, but all right, just before you all start, we had a virtual witness for Senator McKay's bill, who is now back online. We're going to hear from him first, if his audio works. And just for the record, this is for Senate Bill 857. James, if you can unmute, we're ready to hear you. Can you hear us?
Can everyone hear me this time? I think that's the more important question.
That is, we can hear you.
Awesome. Thank you very much. Thank you for putting up with that little technical difficulties. I know it's the best and worst part about the virtual world these days. So with that being said, my name is James Rotino. I am the president of the Maryland Off-Highway Vehicle Alliance. I have been the president of this organization as a volunteer for the last 5 years. And over that time, I've had the opportunity to meet legislators. I've met ORV recreational riders throughout the state and landowners, and had the pleasure of working with Department of Natural Resources and opening up Wolf Den Run State Park. When this legislation was first introduced, I took the time to consult with our members and member organizations, and they all supported this bill. During our partnership with the Department of Natural Resources, I've had the privilege of seeing the hard work that they put into developing Wolf Den Run State Park and St. John's Rock, Maryland's only 2 ORV catering facilities. These facilities would not exist if not without the initial passing of the Title Tax Fund bill in 2017. This fund allows us to create and maintain all of the trails within the state of Maryland for ORV usage. I've also seen, as these trails came online, how the added responsibilities for DNR did not necessarily get met with an increase of funding to allow them to fit out those facilities. This legislation would allow that to occur, and it does so in a novel way. This would allow ORV to be the only user group self-funding their own public access throughout the state, something that is truly unique. This would allow them to fund things like the parking lots, the campgrounds. It would allow them to have some flexibility on where that funding needs to go to help better fit the end user groups that are taking advantage of these opportunities. It'll also allow DNR to spend some money on safety and education awareness, allow people to understand the proper and safe ways to sustainably use their ORV vehicle on public lands. It will also allow for diversity outreach to non-English speaking families and riders who want to get outside and enjoy ORV recreation.
All right. Thank you very much.
Thank you.
Glad it worked out. All right. Excellent. Now we'll move on to Senate Bill 890. Welcome.
Thank you, Chairman Smith, and good afternoon, members of the Judicial Proceedings Committee. For the record, I am Janae Fountain, and I'm here today representing the Maryland Office of the Attorney General. I'm honored to testify in support of Senate Bill 0890, which expands upon the Walter Lomax Act. Currently, I'm the Assistant Attorney General in the newly created Civil Rights Division. However, before this, I had the distinct honor of serving as the Walter Lomax Act Assistant Attorney General for 2 years. To date, the Board of Public Works has approved compensation in the amount of $14,281,122.92 to 13 exonerees. And various state agencies have made benefits and services available to these exonerees as well. While the law has been life-changing to these exonerees, we quickly saw that there was some language that needed to be modified. SB 0890 does not drastically change the Walter Lomax Act or remove any of the benefits in place. SB 0890 clarifies certain language and builds upon the Walter Lomax Act in 3 ways. Firstly, it clarifies the ambiguity regarding concurrent sentences and the meaning of the word vacated. Secondly, modifications were made to allow for the equal treatment of all Walter Lomax Act exonerees, regardless of when they were released. Subsections in the Walter Lomax Act starts benefits from the date the individual was released from confinement and limits the time of frame for an individual to file a petition under the Walter Lomax Act, starting from the date that they were released. This language is fundamentally unfair to these exonerees. Lastly, SB 0890 takes into consideration the hardship exonerees face regarding education. This bill prolongs the period during which an exoneree may avail themselves of higher education benefits, extending it from 5 years to 8 years. Exonerees have endured unimaginable hardships for wrongful imprisonment. By building upon the Walter Lomax Act and expanding benefits, we can provide exonerees with the resources and assistance needed to thrive in society. Once again, I urge this committee to consider the profound impact that these amendments can have on the lives of those who have suffered unjustly at the hands of the criminal justice system. And I urge a favorable report on SB 0890. Thank you.
Good afternoon, Chairman Smith and members of this honorable committee. My name is Lauren Lipscomb, and I'm the chief of the Conviction Integrity Unit in the Baltimore City State's Attorney's Office. I've been a prosecutor for just short of 20 years and have prosecuted thousands of cases at various stages within the criminal justice system. As well, I created and oversee the Conviction Integrity Program, which reviews claims of factual innocence in Baltimore City. In this capacity, I have directed the investigations which have exonerated 12 men who are collectively served over 200 years in prison for crimes not committed. Over the years, I've had the privilege of engaging nationally and locally on all aspects of prosecutorial conviction integrity related matters, to include extensive advising to our internal legislative team during the drafting and development of the now enacted Walter Lomax Act. Passed in 2021, the act represented for us a long-awaited commendable action to ensure that those who had been erroneously convicted received the compensation and benefits that they deserve. However, as with any implementation of new legislation, as we have put the act in use over the past few years, the need for a few tweaks have emerged. Senate Bill 890 provides the necessary corrective measures, which in turn will ensure that the full legislative intent of the bill has in fact been met. I'd like to highlight 2 measures. Anecdotally, we have had individuals who have been released, but yet were not eligible immediately. As the law stands now, this creates an unfair outcome because these individuals cannot access compensation through no fault of their own. As well, education benefits specifically run after 5 years from release from prison, which is quite short when confronted with navigating an educational system successfully after years served in prison. Senate Bill 890 provides tweaks that will ensure more just and fair outcomes for those who have been horribly aggrieved by erroneous incarceration. We urge a favorable report on Senate Bill 890. Thank you for permitting my testimony.
Good afternoon, Chairman Smith, Vice Chair, and members of the committee. For the record, my name is Erica J. Suter. I'm an assistant public defender, faculty member of the University of Baltimore School of Law, and director of the UB Innocence Project Clinic. I urge a favorable report on SB 890. I also support the amendments, which you'll hear about after this panel, proposed by Brown, Goldstein, and Levy. There have been 51 exonerations in Maryland since 1989, when the National Registry of Exonerations began tracking. Exonerees on average serve approximately 16 years of wrongful incarceration. Exonerees are often released with what we think of as their most productive years behind them, the years when they would have started their family and established themselves professionally. Maryland has made great strides when it passed the Walter Lomax Act, but SB 890 corrects the Lomax Act in important ways. It calculates eligibility for benefits from the time of exoneration as opposed to the time of release. It increases the time period from 5 to 8 years for an individual to receive education benefits, and it preserves important due process rights. The additional amendments proposed allow us to reach convictions that certainly ought to be included, such as attempt or conspiracy, but are currently not covered. Developing the evidence to exonerate a convicted person is a time and labor-intensive process that typically takes several years. Prison is a notoriously dangerous and unpredictable environment. I've had clients who have been attacked and killed in prison. I've had clients who've died of disease and illness while incarcerated. Clients often experience the death of parents and siblings while they are incarcerated. If a client has the opportunity to pursue release through parole, a sentence modification, or some other means, they should be able to avail themselves of that opportunity without sacrificing their ability to receive benefits if and when they are exonerated. With regard specifically to the educational benefits, you can imagine when an individual has spent 20, 30 years in prison, how difficult it is to adjust to our society and to all of the technology. And it's certainly logical that they need additional time to be able to benefit from the education that's offered. For these reasons, I would urge a favorable report. Thank you.
Good afternoon, everyone. My name is David Vini. I stand before you as one of the exonerees who has benefited from the Walter Lomax Act. First, I would like to thank you all for what you already have contributed to getting the Walter Lomax Act passed. And these alterations, as it stands now, I myself would not be a beneficiary because although my sentence was vacated in 2005, it wasn't until 2022 that I was exonerated. With the way it's written now, I wouldn't be eligible to receive benefits from the package. And I'm not alone. In my case alone, there was another individual who was named by the lady, accused by the lady, and wasn't exonerated until last year, but he was convicted in 1993. So these small gaps, the act kind of turns the key, but these alterations opens the door so that those who have experienced what I have experienced have the opportunity to receive the benefits of the Walter Lomax Act. Thank you for your time.
Good afternoon, Mr. Vice Chair, distinguished members of the committee. My name is Patrick Gilbert. I'm here on behalf of the Maryland State's Attorneys Association, but I work as a senior assistant state's attorney in Wicomico County, where I run our prosecution integrity unit. And it's in that capacity where I conduct fact-based reinvestigations of credible claims of wrongful conviction, whether a function of actual innocence or substantial procedural injustice. And it's in that capacity I've enjoyed the singular professional and personal honor of meeting men like David Vini and men like Grant Jones. Mr. Jones was convicted of a crime he didn't commit in 1992. My team reinvestigated his conviction, and after discovering compelling evidence that not only was he actually innocent, that the crime he was accused and convicted of never took place, we moved to vacate his conviction in summer of 2023. Mr. Jones can't be here today. He's fighting metastatic stomach cancer, which makes the years taken from him all the more acutely unjust. So I'm here to urge a favorable report on this bill. The language of State Finance and Procurement 10501 currently requires individuals who were released before July 1st of 2021 to have requested compensation before June 30th of 2023. Mr. Jones was released in 1997 when he completed his sentence, but the Circuit Court for Wicomico County only vacated his conviction in August of 2023. We were able to successfully argue that an interpretation of this language that would have required Mr. Jones to have sought compensation at a time when he was statutorily ineligible led to absurd results. And we're grateful to both Assistant Attorney General Fountain and the Office of the Attorney General for supporting that argument and to Judge Chapman for agreeing with us. But because there isn't any meaningful stare decisis in the Office of Administrative Hearings, this bill is necessary to ensure that this interpretation applies moving forward. I have so much to say about this case, about prosecutor-led conviction review in general. So please, I would urge the committee to ask me questions. With that, I'd yield, and I thank the committee for their time and consideration. Thank you.
Thank you. Any questions for this panel? All right. Seeing no questions, we'll move on to the other proponents, Michael Abrams, and then we'll take virtual testimonies from Kashina Cross.
Members of the committee, my name is Michael Abrams. I'm a civil rights attorney with the firm Brown Goldstein Levy, which has expertise in Walter Lomax Act cases. I'm going to ask you to consider a hypothetical. You are in the wrong place at the wrong time. You are arrested for a killing that you had nothing to do with. You are charged with murder and conspiracy to commit murder. The jury acquits on the murder charge, but they convict you on the conspiracy charge. So you are sentenced to life in prison. You spend 10 years in maximum security. Finally, you manage to show a court that the forensic evidence used against you was junk. You clear your name and secure your freedom. But you have to restart your life. You work 2 jobs and you stay out of the justice system. After the Walter Lomax Act is passed in 2021, you file a claim for compensation under the new administrative process, and you are held to be ineligible for compensation because the new eligibility provisions use the term felony, and you were only convicted of a misdemeanor. How can that be when you were sentenced to life in prison? Well, in Maryland, unlike in most other states, crimes are categorized based on the common law, not based on their potential punishment. So misdemeanors in Maryland can carry lengthy prison sentences, including up to life in prison. The eligibility provisions in the Walter Lomax Act were based on similar statutes in other states where felony and misdemeanor don't have this same definition. So in Maryland, by using this language, exonerees convicted of certain crimes, serious crimes, can be ineligible under the Act. SB 890 fixes a few narrow issues with the Walter Lomax Act, and this issue with the term felony is one more narrow issue that can be easily fixed. So we urge the committee to incorporate our proposed amendments, which you can see on page 3 of our written testimony. The committee should also retain the retroactivity enactment provision to make sure that the fixes in this bill reach the exonerees they're meant to help. The Mid-Atlantic Innocence Project joins us in supporting these fixes. The committee should take the opportunity to get these done together. Thank you.
Thank you. And then we're going to take 1 second and then we're going to move virtually for Ms. Cross. She's in the room.
Thank you, Madam Chair. Thank you so much.
Go ahead, Ms. Cross.
Thank you so much, Chairman. I am grateful for the Senate Bill 890. I think that we have to really look at where we are relative to the growth and the progression of the state of Maryland. Our returning citizens have an equity opportunity of nearly $2 million in addition to many of the areas per county, to many of the areas where now we see a persistent, consistent inability to obtain work of a dignity of work that is of worth and of value. And many of them have obtained even doctor's degree and have now readied themselves to return to communities appropriately. When we look at erroneously convicted, and particularly as it pertains to altercations, I enter a plea of favorable with amendments in that as long as we have come, as far as we have come with technological advances in medical science, we have come within a high level of accountability when it comes down to favorableness from test results, from videos, camera scanning, from DNA testing, to where we can get within a very small percentage of error. At which case, I do believe that those that have been erroneously convicted should be returned with the full face of the citizenry that many of us enjoy every single day. I'm grateful for this bill being brought forward as we consider our members of our community, our returning citizens, and that those that have been wrongfully convicted will have not their lives given back, but a right size to what has unfortunately happened. Thank you so much for allowing me to testify.
For the panelists?
We have one other panelist.
Okay, who's that?
Sean Armbers from the Mid-Atlantic Innocence Project.
I don't see them signed up. They could submit written testimony if they have not already.
She was notified by Senator Smith that she would be able to testify this afternoon.
Okay, is she here?
She's right here.
Okay, all right. Then if that's the case, then I can't override the chairman. So 2 minutes, please.
Thank you, Senator Carter.
Thank you so much, Senator Carter. I want to echo what I'm Sean Armbrust, the Executive Director of the Mid-Atlantic Innocence Project, which works to prevent and correct the conviction of innocent people in DC, Maryland, and Virginia. And I urge the committee to issue a favorable report, but want to specifically highlight the amendment that my colleague at Brown Goldstein and Levy has presented to you today. I was involved in the conversations that led up to the passage of the Lomax Act and witnessed how carefully all of the legislators involved and all of the advocates involved on all sides took this piece of legislation. We all wanted to get it right, to make sure that the deserving people were compensated, and also to make sure that there weren't floodgates problems on the other end. And so, as we've seen from the Attorney General's suggested legislation, there were a number of areas in which the bill hasn't quite worked as intended. And the issue my colleague from Brown Goldstein and Levy highlighted is another one of those issues. We initially agreed to limit compensation to those convicted of felonies because we didn't want the system flooded with low-level misdemeanors, things that in most states are unlawful entry or, a simple assault charge. What we didn't contend with is the way in which Maryland classifies conspiracy, attempt, and solicitation. So I'm here to advocate today on behalf of the legislation of the amendment that Brown Goldstein has proposed. We'd also consider other language if people think it's a more appropriate limitation, but we don't think anyone intended to limit someone who is sentenced to life for conspiracy to commit murder to not receive compensation. So we'd urge a favorable report with that amendment, and I'm happy to answer questions about the amendment.
Thank you very much. Questions from the committee? Seeing no questions, that would conclude the bill hearing on Senate Bill 1095. Next up,
Senator West. Got two bills.
Senator West, are you up with Senate Bill 792?
Yeah, 890.
I'm indeed.
Oh, that's what's in.
Yeah, sorry.
So this is 792?
Well, that's what's here.
Yeah.
Yeah, I'm sorry. Yes, you may proceed. Senate Bill 792.
Thank you. Thank you, Madam Chair. So it's a pleasure to be here to present Senate Bill 792. You'll notice I have dozens of witnesses. And that's because I don't think I need witnesses on this bill. And you'll see in the next bill as well, there are no witnesses. So hopefully these bills will go quickly, and I will redeem myself in the eyes of members of the committee for having taken a lot of time yesterday answering questions. So under Maryland law currently, juvenile courts have exclusive jurisdiction over youth who are 10, 11, and 12 years old who commit certain violent crimes. Senate Bill 792 would expand the court's jurisdiction to include youth who are 10, 11, or 12, and who are accused of use or possession of a firearm, as well as youth who are 10, 11, or 12 who are accused of any crime, so long as they have been arrested 2 times before. This is necessary legislation, and I note that the drafter, and when I went back and read it this morning in anticipation for this hearing, I don't know why the drafter did this, but the drafter mistakenly took out 10-year-olds from the bill. So I'm going to have an amendment prepared which would add 10-year-olds back into the bill. So the bill will now cover, and the statute will cover 10, 11, and 12-year-olds. The first part of the bill, the part that covers youths who were accused of use or possession of a firearm, I believe is already covered by Senate Bill 744, which we passed a couple days ago and which will be on the House floor in second reader tomorrow. So that part of this bill could be amended out or deleted before we consider passing the bill. That leaves the second part of the bill, and that relates to youth who've been arrested on 2 prior occasions and who are now arrested a 3rd time. This could extended testimony about the recent uptick in youth under 13 running drugs and committing crimes on behalf of older criminals. It's no surprise that this is occurring because currently there are no real repercussions for someone under 13 who commits these acts. Why would the older criminals take the risk of getting caught, prosecuted, convicted, and imprisoned when they can outsource the crime to someone under 13 years old who's practically immune. This bill accords to the juvenile 2 arrests without consequence. But the third time the youth is arrested, there needs to be a serious attempt to turn the offender around by giving him or her the sort of services that a juvenile court can require. I need to emphasize that this bill is not intended to put youths under 13 years of age into incarcerated facilities. The purpose of singling out kids who use I was going to say use guns, but that's out of the bill now, who repeatedly commit crimes and making them subject to the jurisdiction of the juvenile court is to ensure that these wayward young people get the services that they so badly need and that the juvenile court can require. As this committee is aware, just last week, I introduced a bill to set up a task force to study the sort of services that are assigned by our juvenile courts and to determine how to make sure that these services are effective. This bill is therefore a complement to last week's bill. We not only need to be in a position to render effective services to youthful offenders, we need to identify the young people whose lives are going off track and enable the juvenile courts to make sure that they are given the necessary services. This bill should thus be seen as a complement to my other juvenile bill in order to not only prevent, but preempt juvenile criminality. So I appreciate the committee's consideration of this bill and would be happy to answer any questions the committee may have.
Any questions for the sponsor?
Senator Sidner.
Thank you very much. Senator, are you familiar with the concept of abate by arrest?
I'm sorry, it's hard to hear.
Are you familiar with the concept of abate by arrest?
Abate by arrest?
Yes.
No.
Okay, it's a concept of essentially going in and you have issues of crime in a certain part of whatever community. You go in and you just arrest folk willy-nilly just to cause them get them off the street. It was an issue that I believe Senator Carter dealt with in Baltimore City under one of our former mayors. Anyway, if you're not familiar with the process or the concept, I would say check it out. That's why line 6 and 7 on page 2 would give me problems, because just because you're being arrested doesn't necessarily mean that you're up to no good. So I just wanted to say that.
Thank you for that comment. I hear what you say, and it maybe we'll come up with an amendment to the bill to try to more specifically delineate the sort of arrests which should trigger this bill. But again, the important thing of this bill is to get youth who need help the help that they need, and not just to send them back home again without any consequences.
Thank you. Any further questions? Senator, there is one favorable with amendments individual that signed up to testify.
Okay.
Is Kashana Cross here? Kashana Cross. Oh, I'm sorry.
Thank you, Madam Chair, and thank you, Senator West, for bringing this bill. I do favor with amendments in accordance to what was just spoken by the good senator that challenged the aspects. I also want to acknowledge that we do have the police accountability bills in place now, to whereby the police can be held accountable for any of the baiting actions. But I do know, having been married to a young man from Cabrini Green in Chicago, that baiting was pretty much something that they used to actually control areas where ethnic Black communities exist. So I ask that your bill be put in place explicitly to where there cannot be targeting of communities of color. I do ask that if you're going to lower the limit down to 10, that you include in your bill an opportunity for the parents must be present in the life cycle of anything dealing with juvenile youth and court cases relative to these very serious crimes. I do not like the language in as much as to allege that they are troubled, because I also want you to acknowledge mental health and wellness is a real threat in our communities. And relative to this bill, I would ask for an amendment to support counseling services, to support mental health and wellness evaluation, because if we do have something that is a hidden disability, that should be taken into respect with your bill. So for Senate Bill 0792, favorable with amendments. Thank you.
Thank you very much for your testimony. A lot of what you said, I totally agree with, especially the last part. My other bill, which you weren't here for, I guess, last week I presented, is a comprehensive study of social services, juvenile services rendered to juveniles across the board, from mental health services to drug services, et cetera, to try to figure what we're doing right, what we're doing wrong. And
Senator West, I don't want to interrupt, but there was there wasn't a question that was asked. She was testifying in your favor of your bill with amendment.
Okay.
So I don't think it's necessary for you to respond.
All right. Thank you.
Thank you. Before you go, Madam Mayor, I was given a note, point of personal privilege. Jordan McClure, that is my fellow this session, has said hello to you.
Hello, Jordan McLong. Very nice. And thank you so much. He is a wonderful asset, I'm sure, as much to your team as he's been to mine.
Thank you so much. Okay, next up, we have two signed up unfavorable. Jeremy Zacher and Nishana Kress. Are they here?
Madam Chair. Good afternoon to the committee. My name is Jeremy Zacher. I'm an assistant public defender in Baltimore City's Juvenile Division. Maryland Office of the Public Defender asked for an unfavorable report on Senate Bill 792. This is yet another bill designed to bring more fourth, fifth, and sixth graders into the juvenile justice system, despite volumes of study, science, and evidence-based practices, which tell us that involving preteens in the justice system is unproductive and detrimental. More often than not, young children are incompetent to stand trial. Young children lack the neurocognitive development and ability to understand and appreciate the court process and their role in it. Young children often languish in the justice system while the court attempts to evaluate the child and determine the best way for the child to attain competency, if that's even possible, and this creates a delay in services. Senate Bill 792 is particularly egregious because it seeks to grant jurisdiction over preteens who have twice been arrested, not charged, not found involved, not found delinquent, merely arrested. The bill does not define what an arrest is, but Maryland law has a broad definition which could include merely being detained and subjecting the arrestee to the actual physical control of the police. The arrested child need not be taken to bookings or be charged, and including young children with merely 2 or more arrests in our juvenile justice model would not only punish the children who may have never done anything wrong, but it could encourage law enforcement to conduct brief detentions of youth just to place a mark on their records, which could later be used to bring them into the juvenile jurisdiction before the age of 13. Maryland Office of the Public Defender is asking for an unfavorable report. Thank you.
Thank you very much. Is Kimberly Watts here? Seeing no further witnesses for this bill, either favorable or unfavorable, no further questions from the committee, that will conclude the bill hearing on Senate Bill 792. All right, Senator West, you're up again with Senate Bill 1067.
Thank you, Madam Chair. It's a pleasure to be here to present Senate Bill 1067, entitled Baltimore County Speed Monitoring Systems, Interstate 695. Those who live in the Baltimore area and visit the city via the Jones Falls Expressway are by now familiar with the speed monitoring systems that have been installed along the JFX. This speed monitoring system was just installed 2 years ago after the General Assembly passed authorizing legislation. It has accomplished exactly what it was intended to do, namely cause drivers on the JFX to slow down and drive more safely. In fact, so many drivers on the JFX have slowed down that the income produced by the speed cameras is a fraction of the original predictions. I confessed that I voted against that bill 2 years ago. I thought it was going to be a cash grab by Baltimore City to extract money out of mostly my constituents, because my constituents live at the northern end of the Jones Falls Expressway. That has not turned out to be the case. I believe I was wrong in voting against that bill 2 years ago. Again, because the bill has accomplished exactly what it set out to do. It has not turned out to be a cash grab. Instead, it has slowed down traffic on the Jones Falls Expressway and improved driver safety on the Jones Falls Expressway. So this year, 7 of the 8 Baltimore County state senators are sponsoring this bill to place similar speed cameras on the Baltimore County part of the Baltimore Beltway. The reason is simple. There are drivers on the Baltimore Beltway who seem determined to set world speeding records. Each of the sponsoring state senators have had the same experience. We are driving along the Baltimore Beltway at a reasonable speed when a car passes by us, traveling at rocket light speeds of 90 miles an hour, 100 miles an hour, and higher. When this happens, it is shocking and it's scary. We cringe, convinced that we're about to witness a fatal accident up ahead. Clocking speeds like this in work zones is terrible, but driving 30 to 50 miles an hour over the speed limit on other parts of the Beltway is nearly as dangerous. Senators Brooks, Hedelman, Klausmeyer, Salling, Sidner, and Washington join me as co-sponsors of this bill. We consist of all of the Baltimore County state senators whose districts include a portion of the Baltimore Beltway. Senate Bill 1067 will bring the same monitoring system to the Baltimore County part of the Baltimore Beltway as currently exists on the Jones Falls Expressway. There would be up to 16 speed cameras operable, with only 4 in use at any one time. The violations enforced by the speed monitoring system will be used to fund road repairs and safety improvements on the parts of the Baltimore Beltway that lie within Baltimore County. The bill has 2 amendments. The first adds co-sponsors to the bill to include all 7 of the sponsoring state senators from Baltimore County. And the second transfers the responsibility for installing and operating the speed camera system from the government of Baltimore County to the Maryland State Highway Administration. In this respect, it's different from the JFX bill. The JFX was built by an organization called the Interstate Division for Baltimore City many, many decades ago. And since that time, there's been a consortium between the State Highway Administration and Baltimore City, whereby the control of the Jones Falls Expressway and the responsibility for all its maintenance has been assumed by Baltimore City. So the city controls the highway and its pertinent shoulders and other road parts, and was able to install the cameras on land that it controls. The Baltimore Beltway, by contrast, is totally controlled by the State Highway Administration. Baltimore County doesn't control the land at all. And therefore, the original bill, which provided for the county to install the cameras, was incorrectly written, and we're now transferring responsibility to the State Highway Administration. The SHA folks told me the other day, after a hearing in which they appeared here, that they were copacetic with this bill so long as it did not require them to initially install 16 cameras. I said, it says up to 16 cameras. They can install fewer as a trial project to see how things go. So it doesn't require 16 cameras. It says up to 16 cameras. With that, I think I have the State Highway Administration's support on this bill, although I note that they have not filed any testimony one way or the other. And with that, I recommend this bill to you, hope for a favorable report, and we'll be happy to answer questions.
Thank you very much, Senator. Questions from the committee? Seeing none, that will conclude the hearing for Senate Bill 792. Do you want to do, I see Senator Gallions here. We'll go to Senate Bill 838.
Good afternoon, Mr. Chair and committee members. For the record, Senator Jason Gallion, District 35, Hartford and Cecil Counties, to introduce Senate Bill 838, Vehicle Laws, Lighting, Privately Owned Vehicles. First off, I'd like to thank this committee for its favorable passage of this legislation last year. Where it ended up, it ran out of time when it got across the street over in the House of Delegates. To recap, this bill authorizes the fire police of a volunteer fire company to equip their privately owned vehicles with red and white lights rather than only red, which is current law. And after conversations with the Maryland State Fire Association, this version of the bill will allow for privately owned vehicles to be equipped with red and white lights or red and green lights. So that is the one change allow a choice. They could do the red and white like we had last year, or they could go with a combination of red and green. You'll notice on some state highway vehicles, they have that green. It really shows up quite nicely. By allowing the fire police to use these variations of lights, it will help increase public safety by making it clear to oncoming traffic they are approaching a possible accident scene. So another real quick recap on fire police. So oftentimes you'll be on a scene of a 1050 PR or a car wreck, and the fire police will come out and kind of direct traffic, and that helps with the safety of the scene. But when cars come up on that, it's just with just a red light, it's not as visible from a distance out. So this allows some contrast and will lead to better safety. So I respectfully ask the committee for a favorable vote on Senate Bill 838.
Good afternoon, Mr. Chair, members of the committee. For the record, my name is Joel McCray. I'm a past president of the Maryland State Firefighters Association, which represents over 350 volunteer fire, EMS, and rescue companies and about 28,000 members. I would like to thank Senator Gallion and Senator Bolden for introduction of this bill, which will help provide for the safety of our men and women who volunteer as fire police. And with your permission, if I could do a little visual aid. As you know, state highway maintenance vehicles use green lights. They use them in combination with the amber, so they use green and amber lights. We're asking in this bill to allow a fire police to use contrasting lights, either red and green or red and white, or the red lights. But unfortunately, just red lights do get lost into the background sometimes with all the other lights flashing, and they do not have the wavelength that the green lights do. So the green lights are more visible to the human eye and allow for better detection of our men and women who are out there on the highway. Now, we know being on the highway is inherently dangerous. In 2023, 45 emergency responders were struck and killed on the highway. And to date, in 2024, 10 responders have been killed. So it's an inherently dangerous occupation, and anything we can do to help promote the safety of our men and women out on the roads would be appreciated. We are today asking for a favorable vote for the safety of our men and women. And do we have any other anybody to testify? If not, I'd be glad to take questions.
No, I think you're it. Was that number 10 in Maryland already?
No, fortunately, none of those are in Maryland.
Okay.
We have and will continue to do everything we can to keep our men and women safe on the highways.
Excellent.
Yeah, those numbers are nationwide.
Got it. Still too many, far too many.
Yeah.
Okay. Questions from the committee? All right. Thank you very much. Thank you. Thank you, Senator. All right. With that, that'll end the hearing for Senate Bill 838. We'll now move on to Senator Quarterman with Senate Bill 860.
Thanks, Chairman. Colleagues, we good? For the record, Senator Paul Quarterman, District 2, representing Washington and Frederick counties. Thank you for the opportunity today to present Senate Bill 860, studying the location of individuals prior to and following incarceration. There are currently a little over 16,000 individuals incarcerated in Maryland correctional facilities across the state. The 3 correctional facilities in Washington County house a little over 4,600 of them, so about 1 in 3, about 29% actually. There's many schools of thoughts, obviously, regarding reentry, recidivism, how those go together, but I think we can all agree that finding the best and most successful path forward for these individuals is something that we should strive for. Without the proper support system in place, the service is being done to not only these individuals, but also to our state as a whole. So basically what Senate Bill 860 would do, it's a study. It would conduct an annual study, examines and compares certain data points regarding individuals' residence prior to incarceration and on release from state correctional facilities. We need to know some of this information to try to make sure we have the proper support systems in place in order to provide success. Because obviously if we're not providing those services or the necessary support, those that are being re-entered into society, there's a far greater likelihood they won't be successful. And when that occurs, not only we fail that individual, but we fail, our communities in the entire state. So that's pretty much it. It's basically a study just to kind of track some information. I've had some bills in the past about reentry. A lot of the data that we had previously is becoming kind of dated. It's probably about 5 or 6 years old by now. And so we're just looking to get, capture of just some data here. So respectfully ask a favorable report and happy to take any questions.
Questions from the committee? All right, seeing none, that'll end the hearing for Senate Bill 860. Thank you very much. No, Benson's here. She's right here. Senator Benson, welcome. Senate Bill 720, welcome. You have a couple of folks here on a panel. Do you want to bring up your sponsor panel?
Yes, indeed.
Okay, Patrick Gilbert, Morgan Mills.
I'm going to have to give my testimony and run back across.
Okay.
Okay, is that all right?
Yes, ma'am.
Okay, not because I don't love you. It's because I have to run up here and see what's going on. Good afternoon, Mr. Chair, Mr. Vice Chair, and the esteemed members of the committee. It is an honor for me to be back before this esteemed body one more time. I'm here to ask for your favorable report on Senate Bill 720, Correctional Services, formerly incarcerated individuals and individuals on probation, re-entry services. Maryland, with its rich diversity and dynamic communities, is currently grappling with a recidivism rate of 40%. This figure highlights a pressing issue. Nearly half of those released from our prisons are at risk of reoffending. This cycle affects not only just the individuals, but also their families. And it also has a broader implication for our communities and the state's economic well-being. In response, Senate Bill 720 aims to introduce a robust reentry program in Prince George's County designed to offer essential support services, including ID acquisition, housing, healthcare, legal aid, and employment assistance to effectively lower this rate. The necessity of this bill is clear. The hurdles faced by individuals upon release, such as the lack of a valid ID, directly hinders their ability to reintegrate into society by complicating their efforts to find employment, secure housing, and access health care services. Considering Maryland's incarceration rate of 531 per 100,000 people and the significant number of individuals without a high school or GED credential, the path to reintegration is fraught with obstacles. However, access to stable employment has been shown to greatly diminish the likelihood of recidivism, highlighting the critical role of a well-structured support network like the proposed Senate Bill 720. This bill represents more than just an attempt to reduce reoffending rates. It symbolizes a commitment to providing a second chance to those who have been marginalized. It acknowledges the untapped potential within everyone to make meaningful contributions to society when given the necessary support and opportunities. With an annual allocation of $3 million starting in 2026, this initiative reflects our state's dedication to enhancing public safety, upholding human dignity, and supporting the reintegration of individuals into society. By endorsing Senate Bill 720, we are choosing to invest in a safer, more equitable Maryland where every person has the chance to partake in and contribute to our collective success. This bill sets a foundation for a more compassionate, rehabilitative approach to public safety. Therefore, I'm respectfully asking that this committee gives Senate Bill 720 a favorable report.
Thank you very much, Senator. Questions for the senator? All right. Thank you very much. We'll hear from your panel.
Thank you.
Thank you. I know you have to get going, but we're going to bring your panel up. I called Mr. Gilbert. Morgan Mills is you. And we've got a couple folks signed up online. Is Calvin Hawkins?
Yeah.
All right. Go ahead.
Good afternoon, Mr. Chair, distinguished members of the committee. My name is Patrick Gilbert. I'm with the MSAA. I work as a senior assistant in Wycomico County. I'll be very brief. You've heard from the senator how important this bill is. The association sees this as a public safety bill. Study after study, research after research unequivocally establishes that effective, evidence-based, compassionate reentry programs prevent recidivism, makes communities stronger, makes families happier, keeps us all safe. I urge that this bill receives a favorable report. I'll note that it does come with a mandatory appropriation. There's a lot of great literature about how these types of programs, the benefits you reap exceed the cost by a magnitude, 10, 20 times back in terms of decreased recidivism, increased success in community participation, things like that. So again, this is a public safety bill, keeps our community safe. I'd urge a favorable report. Thank you very much.
Call one more time. Morgan Mills is not here, right? All right, Mr. Hawkins, welcome.
Chair Smith, thank you for giving me this opportunity. As you know, I am a council member in Prince George's County. I serve at large. I'm honored that you and the Dean of Prince George's Politics, Senator Joanne Benson, have seen fit to bring about SB 720 along with HB 61. As a returning citizen who's been out for the last 30 years, I still feel and remember how it was returning to the community without a proper ID, without a social security card, without any real help. And we were responsible for finding employment, finding housing. And this bill that you and Senator Benson are sponsoring on the Senate side and Delegate Denny Tavares is sponsoring on the House side will go a very long way in helping those men and women who are committed to doing the right thing and making something positive about their life. Thank you for this opportunity to speak to you, and good luck. And I'm praying that this bill is passed. And thanks for having the kind of commitment to returning citizens that will help them to a better way and a better future. Again, thank you very much.
Hey, thank you very much, council member. It's good to see you. Senator Muse has a question for you.
Councilman Calvin, how are you?
I'm great. The man himself.
Good to see you. This gentleman worked on my first campaign 30 years ago, and he has just been a tremendous, tremendous asset to Prince George's County, and continues to give back in so many ways. And I've watched him come a long way, and just in his good work. So tell all of my colleagues on the council I said hi. We got to get together at my house and have a party or something real soon. Got that? Got that?
Got it. Thank you,
All
sir.
right.
Thanks for all that you do.
Thank you. Bless you. Thank you.
Senator Charles just got
Yes,
back
sir.
in the house right here. You want to say something?
Always good to see a good man of Omega. Thank you for joining us today, sir. And I'll be looking forward to seeing you for Q's in Annapolis, which is next week.
We got Kappas, Qs, Alphas, all on the committee, man. All right. Hey, good to see you. Thanks a lot for your testimony. All right.
I will.
Questions for our panelists? No? All right. Excellent. All right. So we're going to switch over to favorable with amendments. Cam Bridges. Not here. Okay. What about Hashima Cross? Madam Mayor, welcome back.
Thank you so much, Chairman. And I do appreciate the opportunity to speak on behalf of Senate Bill, the Senate Bill 0720. I believe, forgive me, my screen.
You got
shares
it.
a little
7:20.
slow.
That's right. You got
Okay,
it.
super. Okay, the correctional services for formerly incarcerated individuals. I've had the unique opportunity of working with many of our returning citizens and as well with the state's attorney, Aisha Brayboy, and her expungement fairs that she's had across Prince George's County. Listen, this is a bill that adds dignity and respect back into our communities for those that have found themselves on the other side of the law and have recovered themselves back into communities. This annual budget for the fiscal year starting in 2026 and each fiscal year thereafter with an appropriation of $3 million for the program, I believe it's an opportunity for us to reinvest into our communities. We are honored that Senator Benson has brought this bill forward. As we know, many of our formerly incarcerated members of our community are avid volunteers, avid supporters, and Men in the Gap, for example, is just one of our nonprofit organizations working with the Hope in Action Task Force and the Hope Collective on the Prince George's County to combat the recidivism and also to combat the pipeline that many of our disenfranchised youth have found themselves going down, providing that much needed male-based mentorship that has now changed the tide on many of our young folks who may have taken that path. This $3 million is a drop in the bucket for what we as a community need by way of public safety and the reinvestment in our community. I humbly urge you to equally put in this bill opportunities to support people, organizations like Men in the Gap, ran by the Pastor Balbora and his team that have also put mentorship on the ground. When we're talking about people who have walked that walk, they have the ability to talk the talk of recovering and renewal. So thank you so much. With that amendment, adding in specific organizations who will help keep this bill on track because they have a vested interest not only in its success, but in community. Thank you so much.
All right. Questions from the committee? All right, seeing none, that'll end the hearing for Senate Bill 720. We'll now move on to Senator Sidnor. You ready to go? If not, we can go to.
Check us out right now. Come on up. All right, as my panel is joining us, percent. All right, Charles Sidnor, Senate Bill 840. Good afternoon, everyone. Automatic license plate readers are deployed on things like police cars, overpasses, street lights, and they capture images of vehicle license plates which are stored in databases. While ALPR can provide a vital source of information to law enforcement officers, there are few or no restrictions to protect privacy rights. While addressing ALPR privacy concerns, Justice McCullough of the Supreme Court of Virginia stated, modern technology enables governments to acquire information on the population at an unprecedented scale. The ability to amass information must be curbed by adequate privacy protections. Senate Bill 840 helps provide some of those protections. This legislation introduces minor yet crucial changes to the definition of historical data in the public safety article. Under the current definition, historical data means any data collected by an
ALPR system and stored in an automatic license plate reader database operated by the Maryland Coordination and Analysis Center or by a law enforcement agency. First, Senate Bill 840 introduces language to allow the database to be operated by or for the Maryland Coordination and Analysis Center or by or for a law enforcement agency. Additionally, this legislation adds to the definition to include any data collected by ALPR system and stored through cloud computing, kind of bringing things up to the 21st century. Finally, SB 840 explicitly states that captured automatic license plate data is the property of law enforcement agencies and may not be sold for any purpose. Senate Bill 840 provides the data protection that Marylanders deserve, and as such, I respectfully request favorable report on Senate Bill 840. And with that, I'll have my panel present.
Good afternoon. If you don't mind. Sorry. Government Affairs at Flock Safety, one of the nation's leading providers of automated license plate readers known as ALPRs. And I'm here to express our support for Senate Bill 840. Senate Bill 840 accomplishes two primary objectives. First, this bill is enabling legislation that would permit providers of ALPR devices who use cloud data storage like Flock Safety to operate in Maryland and to interface with the Maryland Coordination and Analysis Center, known as MCAC. Second, the bill strengthens the existing ALPR statute with additional privacy and security protections. Under the current interpretation of the existing statute, law enforcement agencies are prevented from sharing data with MCAC through any ALPR system that uses cloud storage. It's important to note that the underlying statute was enacted in 2014 before the widespread adoption of cloud-based computing. To be clear, Flock Safety is not the only ALPR vendor who uses cloud-based data storage. Furthermore, this legislation does not favor any ALPR vendor, nor does it mandate that MCAC or any law enforcement agency change whichever ALPR system they use currently. I also want to briefly mention two areas of the bill that strengthen existing privacy protections. First, the bill clarifies that automated license plate data captured in accordance with this section is the property of law enforcement agency. This provision makes it clear that the law enforcement agency alone owns the data and not the vendors. Second, the bill states the ALPR data may not be sold for any purpose. Flock Safety does not sell data, nor are we aware that this is a practice, but we want to ensure that this was codified and are pleased that's in the bill. If this legislation were passed, law enforcement would have the option to use Flock Safety or any ALPR vendor who uses cloud-based data storage to help address public safety needs for Maryland citizens. Thank you for your consideration, and I urge a favorable reporting of the bill.
Good afternoon, Chair Smith, members of the committee, Drew Vetter with firm Schwartz, Metz, Wise, and Kaufman on behalf of Flock Safety. I wanted to speak a little bit about the fact that we've been working with law enforcement. You've heard references to the Maryland Coordination and Analysis Center. That is a division of the Department of State Police. Currently, all of the ALPR data generated by local departments around the state is stored on servers over at MCAC. So we discussed this bill with them. They initially had some concerns. We had a series of meetings and we worked out some amendments, which if you don't have already, you should have soon. I just wanted to speak to those briefly. The amendments only serve to increase the data privacy and security provisions of this bill. The original version of the bill, as Mr. Kane just said, prohibits the sale of the data. It makes it clear that the law enforcement agency owns the data. But in addition to that, the amended version will clarify that the agency or vendor can't sell subscriptions or licenses for the data. It states that data cannot be accessed by an employee of the vendor unless it's expressly authorized by the law enforcement agency, and prohibits upload of that data external to the law enforcement agency. It also adds to some of the auditing and reporting requirements in the bill. It makes any vendors or employees subject to the enforcement provisions of the bill as well. And with those amendments, which I'm happy to explain further, the MCAC and Department of State Police have signified to us and which is shown in a letter of information that you have that they're okay with the bill. I'd also note that we have the support of the Maryland Chiefs and Sheriffs Association. So with that, we request a favorable report and happy to answer any questions. Thank you.
Good afternoon, Mr. Chairman, distinguished committee members. My name is Lieutenant Brian Carney here on behalf of the Anne Arundel County Police and the Maryland Chiefs of Police and Sheriffs Association. We support House Bill 1081 with amendments which alter current law provisions governing automatic license plate readers known as LPR. The purpose of this bill is to modernize the storage of LPR data while adding additional privacy safeguards. House Bill 1081 grants the flexibility to store historical data on cloud-based solutions in addition to on-premise solutions which are used today. The transition to more advanced, contemporary cloud-based LPR storage solutions not only enhances operational efficiency, but also aligns with modern LPR technology trends which enhance public safety. We believe the integration of cloud storage into LPR offers benefits such as increased options, access to advanced technologies, improved tools for real-time crime centers, and cost savings. Cloud platforms also provide scalability and accessibility, allowing agencies to select solutions tailored to their needs and budget constraints, fostering innovation and efficiency. As with any modernization of technology, there also needs to be additional safeguards for data protections. House Bill 1081 accomplishes this by affirming law enforcement's ownership of cloud-based historical data and prohibiting its sale or transfer to external entities by either the law enforcement agency or vendors. Additional penalties, operating procedures, and auditing requirements extend to vendors to ensure data integrity. This bill does not change current use of LPR, which provides real-time alerts for legitimate law enforcement purposes to include stolen cars, to search for missing persons, and mitigating public safety threats. The International Association of Chiefs of Police cites studies showing cases involved 75% of crimes with vehicles committed every year in the United States. LPR is a necessary crime-fighting tool used in these investigations. Evolving with technology and adding privacy safeguards will contribute to the well-being of our communities. For these reasons, we ask for your favorable report.
Questions for this panel? All right, thank you very much, Senator. I do have another witness signed up. Is Mr. Schneiderman? Are you?
Thank you, Chairman Smith, members of the committee. Franz Schneiderman, Consumer Auto. Just briefly wanted to add a consumer perspective and a consumer voice in support of the privacy protections that this bill involves. You know, there are hundreds of these ALPRs around the states, both in law enforcement hands and in public hands and also in private hands, and they collect hundreds of millions of scans. And that information can, in principle, be used to track rather closely people's movements. And there have been concerns about misuse of this data for immigration enforcement, potentially for people traveling across state lines to get abortion care. And in the consumer world, it's widely used for mass repossessions of people who are a little bit behind in their car payments. People buy the data and use it to find cars they're looking for and do mass repossession. So, you know, we appreciate that this bill would you know, at least limit the ability of law enforcement to sell that information and to sell it to other private vendors, to other vendors. Obviously, it's a lot of it in private hands too, but that's an issue for another day. So we hope you'll support the bill. Thank you.
All right, questions from the committee? All right, seeing none, thank you very much, Senator. We've got one more witness joining us virtually. We've got Mayor Cross. All right, Mayor Cross, you're up.
Thank you so much. And I do echo the need to support this bill. Anything that we can do that automates the licensing process equally, it provides us an opportunity to say that there was fair treatment on the highways. I do echo the agreement that this does not. Are you able to hear me?
We can, yes.
To not sell the data. Are you able to hear me? I'm sorry, I'm having technical.
Yes, we can. We can
difficulties
hear
at
you.
This point, but I do acknowledge this bill and do recommend a favorable with the amendments in clear that we do not sell the data that is being collected. Thank you so much.
All right, thank you very much. With that, that'll end the testimony in the hearing for Senate Bill 840. We'll now move on to Senator Folden, Senate Bill 768.
I know.
Mr. Chairman, Mr. Vice Chair, esteemed colleagues, for the record, William Folden, State Senator for Legislative District 4. Before you today is Senate Bill 768 concerning vehicle laws and lanes of travel and the requirement of slower traffic keep moving to the right. What we have in the state of Maryland is, let's be honest, we're facing looming deficits. We don't have money to improve much needed infrastructure on roadways, especially along different corridors, I-270 being one, I-70, Route 15, other areas around the state. We're at a crisis for our funding of expanding and maintaining roadways. So as a part of that, one of the solutions that we find is there is the opportunity to provide a solution through fluid traffic flow without causing more money or requiring more money by requiring all motor vehicle operators on roadways that are 3 lanes or more to yield and not travel in the left lane the entire time, but follow the rules of the road by moving to the right unless they are passing or overtaking a vehicle. By people that you'll see it, we've all seen it at times. People will travel in the left lane and it causes a backup. It causes driver frustration. It causes many irritations for many drivers, and it's unnecessary. One of the ways we can do to facilitate this is by an education campaign with our citizens, but as well as having some type of standard that allows us to at least post on these roadways and even to some degree, the only enforceable law we have right now is if they're going below the speed limit, which would be causing an impediment to the normal and prudent flow of traffic. Maryland is one of only 5 states that has no left lane law on the books. We have no enforceable strategy, and those other states are Alaska, Nevada, Ohio, North Carolina, and Maryland. There are a number of states that have a keep to the right when slower than normal, when slower than the normal speed of traffic. So I think we can all agree that people get on roadways, they travel at highway speeds that they're comfortable with, and that continues throughout the course of those operating on that roadway. Other states, there's 24 other states that have that requirement that if you're not staying with the normal and prudent flow of traffic, that you must move over. Just a few of those states are California, New York, Texas, Connecticut, Rhode Island, New Hampshire, and that's just to name a few off the top of my head. There's 5 states have a yield to the left lane for overtaking traffic, which means you have to move over if you have someone approaching you from the rear. There are 7 states that have a left lane prohibited unless overtaking or turning left. This is an outright prohibition, and there's a couple of those states, Pennsylvania, Illinois, Colorado, and then there are a number of states that require you to keep all the way to the right, even with the left and center lanes of travel, unless you are passing or overtaking a vehicle. This is a common sense law. This is a law that we've had that we haven't had, that when you were trained in driver's ed, that you were supposed to yield to the right, not only at a 4-way stop, but as faster traffic is moving behind you, you have a requirement and a duty to yield to the overtaking traffic. And that would facilitate a smoother traffic pattern, lower driver frustration, and allow us to find a mechanism to facilitate this smoother flow of traffic without having someone that wants to be the hall monitor like we had in the elementary school wearing the sash in the left lane saying that they're gonna be the ones that monitor the flow of traffic, and too bad, everybody else is gonna have to eat it up behind them. So with that, I would ask for your favorable report. I think this is the easiest bill we got today. So, and I'm happy to take your questions. I would ask for your favorable report on SB 768. Oh, yes, sir.
Whenever I hear this bill, it reminds me of a certain ludicrous song from way back in the day.
It's fair.
It's fair. All right. Oh, I can't say it. I can't say it. All right, we got the mayor. Come on, we got the, it's move, please. Get out of the way. Those are the words they use, right? Yeah. All right. All right. Madam Mayor, you're back up.
Okay, it says that you stopped my video, so you won't be able to see me today. But I
Wait, hold on one second. Oh, we got you. We'll get you up here.
Oh, there I am. Well, I acknowledge the favorable ludicrous song in which you have so eloquently put so deliberately in response to Senate Bill 0768, vehicle laws of the left lane and slower traffic overtaking and being passed. As I travel each day to the Department of Defense in Fort Meade, Maryland, we experience this frustration as a citizen in this great state of Maryland, and flowing from Prince George's County up through Arundel County. I will tell you that that road, BW Parkway, is an absolute disaster. And many of the high traffic wrecks that we see are from the frustration of the citizens who have decided that they've had enough and they're going to cut everybody off to get past the one person who is dragging the line behind time. Not only does it add 10 to 15 minutes to the one-way road, and we're able to traverse, there's really no way to clearly get there, and 32 is another way, but it backs up as well. Primarily because there is a need to expand the roadways of the BW Parkway. I would ask that you consider that as well when we have grown expeditiously in the population here in between those two counties. There hasn't been much movement for the purposes of preserving the green space, we are aware. But when you look at the amount of people that are traversing the roads, we can severely cut down on the amount of critical highway deaths, particularly that block that highway up for hours on hours when there is a tragedy. So I thank you so much for bringing Senate Bill 0768. Coming from many different areas where this is a law that you are to move to the right, slower traffic, that a police officer can ticket you for slowing down the flow of traffic. And not only that, but it is a safety issue. When you stand in that left lane, blocks an emergency person from being able to get to a much needed incident. So thank you again for this bill. It is definitely needed.
All right, thank you very much. Stay safe. All right, with that, that'll end the hearing for Senate Bill 768. We'll now move on to Senator Carter. Senate Bill, which one are you going to take? 727 or 730?
Senate Bill 727.
Excellent.
Senate Bill 727 is a local Baltimore City bill, and so I have members of the Baltimore City administration that are coming up to testify on the panel. It's rather similar to a bill that we heard earlier this session regarding, frankly, the issue, the huge problem of illegal dumping. And this bill is a little different than the other one we heard because we need to change the law or clarify in the law that the Motor Vehicle Administration has the ability to share visual images of license plates and driver's licenses with the Department of Housing and Community Development, a specific criminal justice agency. Sorry if I stumbled through that just a little bit. I will try to be brief, but explain and thoroughly what the bill does and why we need it. So since 2005, this unit, the Special Investigations Unit within the Department of Housing and Community Development, has been authorized to install surveillance systems at dumping sites to enforce provisions of the state's illegal dumping law. All members of this unit are sworn special enforcement officers and are appointed by the Baltimore Police Commissioner as a condition of employment within the unit. Currently, this unit, the SIU, investigators have access to MVA driver and vehicle records, which are used to identify individuals and vehicles used in illegal dumping, as well as locating the individuals, estates, landlords, and agents associated with the properties that the Department of Housing and Community Development is seeking to investigate and or serve. However, because it is unclear whether or not the Department of Housing and Community Development is itself a criminal justice agency, even though this unit is a criminal justice agency, the Motor Vehicle Administration has not been able to share driver's license photos with the SIU per a specific provision of the Maryland Transportation article, which this bill seeks to clarify. So if the SIU were to be given access to these driver's license photos, it would not only assist the SIU investigators with identifying suspects in illegal dumping cases, but it would also assist them with positively identifying individuals being served subpoenas for upcoming court hearings with the Department of Housing and Community Development. For the reasons stated and for what you'll hear after me, I would urge a favorable report. Thank you. I'm going to ask for the panel before questions.
All right. Good afternoon, Chair Smith, members of the committee. Nina Themelis, Director of Government Relations for Mayor Scott, here to testify in support of Senate Bill 727 on behalf of the Baltimore City Administration. As our sponsor, Senator Carter, outlined, this bill would allow us to have more direct access to MVA photos in order for the city's Special Investigations Unit to conduct its investigations into illegal dumping incidents. The Baltimore City Administration has undertaken several efforts to reduce and deter illegal dumping during this term. Within the last 6 months, we've added 30 additional illegal dumping cameras throughout the city in order to expand our ability to identify and hold accountable those who are choosing to illegally dump. This bill is one of 2 pieces of legislation that the administration has put forward this session to help us in our effort to curb illegal dumping. The other bill will allow the city to use images obtained from our surveillance cameras to help identify those who are illegally dumping. In reference to this piece of legislation, we have 2 representatives from the Department of Housing and Community Development to speak further about the need for this piece of legislation, and we request a favorable report for SB 727. Thank you.
Good afternoon, Mr. Chair and members of the committee. Stephanie Murdoch, Director of Legislative Services for Baltimore City DHCD, here on behalf of the administration in support of SB 727, which will provide better access to MVA photos for Baltimore City Special Investigations Unit, thereby decreasing the amount of time it takes to obtain a photo from the MVA, which will aid in the identification of illegal dumpers. Presently, SIU is unable to review the MVA driver's license photos without first going through the Baltimore City Police Department, per a specific provision of Maryland Transportation article. This legislation would clarify for the purposes of this section that DHCD SIU is deemed a criminal justice agency and can receive photo images by adding criminal justice agency to include Baltimore City DHCD under the criminal law article. Having better access to these photos will assist our investigators in identifying these suspects. As an example, we had a single individual dump on 9 separate occasions over a 4-month period. It wasn't until the 8th dumping that we obtained the MVA photo and were able to identify him and file criminal charges. He dumped the 9th time on the same day that charges were filed for the first 8 cases. In our experience, once the dumper has been identified and contacted, they curb their behavior. Being able to quickly identify dumpers and get in contact with them may significantly decrease illegal dumping in Baltimore City. We respectfully ask for a favorable report and stand by for any questions. Thank you.
Thank you, Mr. Chair. I don't know who wants to answer it, but I just have a couple questions. I don't know if the Mayor Scott's representative that's here.
Likely be myself or the rep.
Yeah, one of you can step up. So as far as I heard it being mentioned, but as far as the illegal dumping, it's already a crime, correct?
Step up.
Yes, thank you. Stephanie Murdoch with DHCD. Yes, illegal dumping already is a crime. Sometimes although we have a number of cameras in place to try to catch folks in the act, sometimes we need additional access to photos from the MVA. Maybe our images aren't clear enough. So yes, it is a crime and we're actively pursuing these folks. We're just hoping to bolster those tools.
So you're able to collaborate then through existing law with a law enforcement agency that has access to the MVA files?
We are currently able to collaborate with the Baltimore City Police Department, but that does take a good amount of time, and this bill would help us have more direct access to those photos.
So does the Baltimore City Special Investigations Unit, that we're trying to give them basically authority as a law enforcement agency to be able to have access to this, a criminal justice agency? But they're not a law enforcement agency. Do they attend a law enforcement academy anywhere in the state?
I'll turn it over to our director of the Special Investigations Unit about
Thanks.
the certification.
Thank you.
You're doing Seth Greer with Baltimore City DHCD Permits and Litigation. So we don't classify them as a law enforcement agency, but I believe under the statute that there is it's different in terms of how they're classified within what's being required. I believe they're called a justice agency.
Criminal justice agency is what they're asking.
Not a law enforcement agency, and is defined within that. We believe in our review and what's required in there that the Special Investigations Unit would certainly meet that definition.
So how long is the training that your agents in the special units and investigations unit go through? They go through an academy of any type?
Well, they are sworn through the Baltimore City Police Department as special enforcement officers. There's no academy per se.
There's no academy, like it's just at the direction of the mayor.
Yes, sir.
So you want to give access, this bill is asking to have access to otherwise non-public databases by untrained personnel at the direction of the mayor, who has no authority over a state database.
Well, I would say they're certainly not untrained, but I mean,
You just said they were.
Well, but they don't go through a law enforcement academy. That's different than being untrained. They are certainly trained by the agency as far as how to use this information. But they already have access to MVA records through driver's license and other information. We also have information through other subscriptions that we have to obtain personal information. So we're certainly familiar with that.
But do you not see that concern that we're trying to give authority to the mayor of a municipality, the authority to have access to a state-run agency's database?
Again, yes, I understand your question for sure. And we currently have that in a sense, not necessarily to the photos.
Not to that degree.
But we have driver's license information and personal information as far as that's concerned.
Yeah, because the photos are something that's concerning, because there's already a driver in the MVA letter. It says that there's a Privacy Protection Act to protect people by preventing identification of individuals through photograph signatures. They're specifically controlled through this legislation, which generally prohibits the disclosure of photos or signatures.
Except as if you're defined as a criminal justice agency, which we believe the Special Investigations Unit is.
Okay, it's not a state agency, but okay, thanks.
Thank you.
All right, further questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator Carter. All right, I think you have one more bill, right?
I think it'll be rather quick, Mr. Chair. I just gotta go to the desk here. I would have my bills on the other committee.
I think
That's you pick and choose what you do.
this will be Senate Bill 732, Senator Carter.
Thank you very much, Mr. Chair. For the most part, if you don't mind, committee colleagues, I'm going to talk from the heart and from my experience so I can really illustrate the impetus for the bill that I'm bringing and hopefully gain your support. So we've had robust discussions about our current state of our juvenile justice system, our Department of Juvenile Services. And most of us at this point know that there is definitely a preference for in community services, community-based services. And there is definitely not a preference for putting young people in any type of a secured facility when we don't have to. I certainly don't suggest in this bill that we would. However, I have had a multitude of experiences with cases with young people that are charged with offenses, but they are pre-adjudication. And they could also be post-adjudication under this bill, though this bill doesn't specify which one. But when they're pre-adjudication, the Department of Juvenile Services is limited in what it does and can offer them. And so for this period of time, from the time they are charged, I sort of touched on this yesterday with my amendment, until they go to court and the court then orders some services for them, there's kind of some sort of downtime where they are not getting the treatment, programming, and services that they need. Now, recently, and this case is ongoing. In fact, I just got one of those e-filing notifications that always gives me anxiety when I'm down here, because I feel like it's going to call me to do something for the court that I try to avoid until after session. This particular young person, I literally have a disposition coming up in his case on this Friday. And this young man is 14 years old, and he has a really challenging situation where, for whatever reason, he is under the custody of his really wonderful grandmother, who's done everything that she possibly can to get him to comply with rules, go to school, and just listen to her and obey her rules of home. His offense that he's charged with is a minor offense, and he doesn't have any priors prior to this current charge. For the entire time pre-adjudication, we've had these 2-week reviews that you all just realized that we have, some of you that may not have been familiar, because we put in our new bill that those 2-week reviews can be waived pre-adjudication. The reason that we had them is that the grandmother had become extremely frustrated with the fact that he wasn't obeying the rules of the home. He was not attending school regularly, and he was just acting up and not listening to anything that she was asking him to do. And his offense was not so great that he could be legitimately detained in a secure facility. And when I talked to him in depth about, because I took the approach with him, why don't you just do what you're supposed to do, and then your case is going to go a lot better. We'll be able to get a much better outcome when your case comes up if you just do what you're supposed to do. You keep hearing your grandmother saying she's fed up, she can't handle it anymore, and she literally asked for the court to detain him because she just wanted him out of the house. So the court really couldn't detain him because offense didn't warrant it. But the court looked for shelter services for him and could not find any. So in the absence of any shelter service for this young man, what happened? He got detained when he didn't need to be, ripped away from the home as the grandmother wanted, and put into the detention facility. And there he sits until hopefully Friday, when the case might get resolved, and maybe he'll get ordered to some probation or something where he'll get the services that he needs. But a year ago, his older brother, just 2 years older than him, was murdered in front of him. And when I asked him, why won't you just go to school? Why won't you just do what you're supposed to do so you can get out of this trouble? His response was, after my brother died, I really don't care about anything. I don't care about people. I don't care about life. I don't care about school. So it's not like I'm intentionally not going to school and doing what I'm asked to do. I just really can't bring myself to do it because I just don't want to be here. I want to be dead. So I tell the court, this young man has got to have some mental health intervention, serious, not just asking them to sign onto a Zoom. He needs serious intervention. He's depressed. And when people are depressed, and when they are angry, and when they are overcome with grief, especially when they're in young bodies and minds, they tend to act up and not conform with societal rules. We didn't have any place for this person to go. There was no shelter facility, so he's in a detention facility until Friday, and maybe longer. Thus, the impetus for the bill before us. I have a vision where we would have a facility that would be able to accommodate young people, not even always in the Department of Juvenile Services, not necessarily always adjudicated delinquent, but a situation like this, where the grandmother's saying, there's nothing I can do, take him. And we know that he needs mental health treatment. He needs a good, strong educational system. He needs mentorship. He needs counseling. He needs caring individuals around him that fuel him and make him believe that he is loved and valued and cared for. Because when people believe they are valuable, that is when they begin to be better. But when they believe they are worthless, that is when they tend to not do anything that we want them to do. And so my vision is that we would fill this void in Maryland of no actual holistic approach, locations, facilities where young people can go and receive the treatment, the programming, education, sports, entertainment, academics, but most importantly, mental health treatment. Now, I know the department has written some opposition saying, oh, we already do this. Well, if they already did it, then we wouldn't be in the dilemma that we're in, and they're not doing it well, and we aren't putting enough emphasis on it. And so this bill would require the Department of Health to work with the Department of Juvenile Services, Department of Social Services, to figure out a way to create a facility that can provide for and accommodate these children that are falling in the gap, these children that don't warrant jail, secure detention. Shelter care is not adequate for them. They need a much stronger intervention, not as a punishment, but as a show of care, that we care about your trauma, we care about your life, and we want to help you be better. And so to me, it's a common sense filling of a void that I would hope we could I would urge a favorable report. It really troubles me that the only option for this child, who has now been told many times by his own grandmother that she does not want him there. That's not helping his mental state. So the only alternative to build this child up is to put him in an environment where he's care and treatment and services. With that, I will end my testimony. We have to do something more than what we've already done if we're serious about saving these children and saving our own future, because they are our future. Thank you.
So questions for the senator? Senator Charles has a question.
I think this is spot on, Senator Carter. You know, there was we had a press conference about a week ago about like $111 million for behavioral health. Do you think there is any way to cross-reference the two so we have a lot of those resources going towards stuff like this from behavioral health standpoint?
So I think so. I think there is. I think there has to be a will to do something more than these community-based and home-based services, though, which is what our preference is. But there are some situations like this young man where we need to just go ahead and say, we're going to take you out of the home. You don't have to go to jail, but here's a place that can give you everything you need. We just don't have it.
Okay. Yeah, now we have to, with all of these organizations that we just gave all this money to, we have to make sure they're stepping up into the gap to fill these needs specifically, especially for kids like this. So thank you for bringing this bill.
Thank you.
Further questions from the committee? All right. Thank you very much, Senator Carter. I've not missed anyone who wished to testify on this bill. Is that right? Come on up. Yep.
Hi, I'm Patrick. I think I had signed up. Oh, okay. Good afternoon, Patrick Gilbert on behalf of the Maryland State Attorneys Association. I work as a prosecutor in Wycomico County. Senator Carter is absolutely correct. There is a void for children suffering from severe mental health challenges, from severe substance abuse issues at this level of need. dedicated treatment like this is absolutely essential, both because kids are fundamentally different from adults. So we shouldn't be treating them like adults in adult inpatient substance abuse programs. And because substance abuse and mental health treatment are different, we shouldn't be giving children detention when what they need is targeted treatment. These sort of broad spectrum remedies like putting them in detention just don't work to solve these issues, certainly not as effectively as the type of treatment envisioned by Senate Bill 732. Without options at the state level, which is what we're currently dealing with, the Department of Juvenile Services has closed dedicated substance abuse facilities. I think most recently Meadow Mountain was closed a couple of years back. Kids, particularly in under-resourced communities, don't have anywhere else to go, and the default is not doing anyone, particularly delinquent youth, any favors. This is a really important bill. It's a really great idea. And I would urge this committee's support on behalf of both the State Attorneys Association and my boss, Jamie Dykes, the State Attorney for Wycomico County. Thank you all.
Hello, my name is Sarah McKinley and I'm a student social work intern with the Office of the Public Defender in Baltimore City. So this bill is important to me because I have been personally impacted by this particular intervention. My mother was mentally ill and an addict, which resulted in me being placed in foster care when I was 11 years old, where I remained until I aged out. I experienced many adverse childhood experiences throughout my childhood, which resulted in me developing my own mental health issues. I began abusing substances very early in my adolescent years as a way to self-medicate, as well as engaging in many other unhealthy behaviors. Between the ages of 17 to 18, I participated in inpatient substance abuse treatment on 3 different occasions. I was at the Jackson unit in Allegheny County for 3 60-day stays. And during my last day, I was transferred to the Catoctin Summit Adolescent Program in Frederick County, where I remained for 5 additional months. During my time at these facilities, I participated in individual and group therapy, as well as other trauma-informed, evidence-based therapeutic interventions that helped me to address my trauma, as well as to learn healthy coping skills. I found my calling in social work during that time. Before I went into residential treatment for the 3rd and final time, I didn't believe I had a purpose in this world. I never really knew what it felt like to belong anywhere or to anyone. I felt broken and helpless. The intensive therapeutic interventions I engaged in saved my life. I used to be ashamed of who I was and where I came from, but I learned that there's strength and power in telling my story and that I could use my own traumatic experiences to help empower others. I was saddened to learn that these facilities no longer exist. Without them, my life could have been much different. I don't believe I would be standing here today using my voice, knowledge, and lived experience to advocate for other kids that need this intervention. For these reasons, the Office of the Public Defender respectfully requests that the committee issue a favorable report on Senate Bill 732. Thank you for your time.
Thank you very much for your testimony. Thank you for sharing your story. Questions from the committee? All right, thanks. We're going to hear from our 2 virtual panelists, and then we'll wrap it up. Mr. Means, Dr. Means, welcome. You're up.
Thank you. Thank you. Good afternoon, committee members. My name is Dr. Ronald Means. I'm a child and adolescent forensic psychiatrist, and I'm here to offer testimony in support of Senate Bill 732. I'm also here as a representative of the Maryland Psychiatric Society, which also supports the bill. So we think this bill offers a good step in addressing the needs of youth with a combination of delinquency and mental health problems who are currently not being served effectively. As a community psychiatrist, I treat youth who have this combination of problematic behaviors and mental illness. Sometimes we hit a wall when it comes to treatment options. And as the senator said, we sometimes even have to suggest, telling families to wait until there's further offense to actually get the services that they need. I appreciate that whenever possible and safe to do so, youth should be served in the community and in their homes, because it's clear that successful engagement of youth and their families in treatment offers the best outcomes. We always support bolstering community-based interventions. But unfortunately, there continue to be a number of youth who are falling through the cracks, specifically youth with low-level offenses that do not prompt detention or placement post-adjudication, but who also fail community-based interventions are particularly hard to serve. Similarly, there are also youth with repeated status offenses who fail to engage in services. These youth present a treatment challenge because many do not have the supports in place to be successful in the community, or they have behaviors that are just too unstable to engage in community-based services. Many have family members who are trying to keep them home, but they really feel incapable of managing the child due to their limitations or ongoing resistance on the part of the child. Despite having a combination of mental health needs and behavioral problems, these youth are often not well served or don't qualify for treatment in traditional acute mental health facilities. The type of facility proposed in Senate Bill 732 would offer a good alternative as a temporary placement in order to allow for thorough diagnostic assessment and jumpstart treatment. The details are complex, but this is a great start to meeting the needs of youth who are currently not being served effectively. Thank you.
Thank you very much, Doctor. All right, is Serena Hallen here? Nope. All right. Questions for the doctor? All right, thank you very much. With that, that'll end the hearing for Senate Bill 732. We'll now move on to Senate Bill 1095. Home monitor? Come on up, yeah. All right, good afternoon, good evening, Senate Judicial Proceedings Committee, Mr. Vice Chair, members of the committee, Senator Smith here to enter into the record Senate Bill 1095, the work group on home detention monitoring. Now, in 2021, we actually passed a piece of legislation that originally constituted this work group. But unfortunately, it never got off the ground. The Senate President and the Speaker of the House both appointed the members that the legislation required of it. But unfortunately, Governor Hogan at the time neglected to appoint 8 members of that committee, and it never got off the ground. Now, the commission or this committee, the work group, was to do a soup to nuts analysis of home detention monitoring in Maryland. They were going to evaluate both public and private options for home detention monitoring, and then they were going to come back to the Maryland General Assembly and give us and the governor recommendations and best practices for how to move forward. Now, the work group was never constituted, and in the intervening years, you should all be now familiar with it. It's been in the news just in the last week or so. The federal money that was used to subsidize the home detention monitoring for those folks that could not afford, for the indigent population, the folks that could not afford to have that service, ran out. And just like that, within a month, the estimates are, I mean, I've heard 600 to 800, a little bit more than 800 people, and maybe some of the folks can speak more accurately to that, have now had that service terminated. And so then the courts are then left for two options, right? You're either going to have to reincarcerate folks or going to have to go through a reanalysis of who's going to be left out on their own recognizance in the community. Neither of these options is ideal, given that we do have the technology and the resources available to make this option available to all Marylanders to keep us safe and to have a more equitable justice system. So this work group is critical, and the reconstitution of it is critical for us to move forward. I will also make the committee aware, and I'm going to put this, Mr. Vice Chair, into the bill file, into the record. My staff has done a remarkable job going through how the whole process works. And right now, there are 5 private entities that operate these home detention monitoring. So this technology is obviously very advanced, and our statute doesn't quite move us toward where the technology is. Whenever we had that initial debate, we left, in my mind, too much latitude for when notification has to be done. So we have funding resources to identify. We've got kind of the mechanics of how that works. You saw Senator McCray come here earlier in the session with his piece of legislation to shorten that time for notification if someone goes out of their geofence location. So I'm going to put this into the record that talks about the 5 companies that operate the technology, how that technology actually functions. Right now, the Department of Public Safety and Correctional Services is the agency that they're responsible for the procurement and kind of the development of the standards for that procurement and operation for the home monitoring systems that to my mind needs another review. The judiciary administers this program. That to my mind needs a deep review and revision. So I will make sure that you all have access to this information. But the thrust of the bill is essentially very simple. It's you've got the legislation, you see the membership. Several entities have come in and support with amendments. Surprise, surprise, they all want to be incorporated into the work group. So I think it'll be left to this committee and in our wisdom to decide who is on and who is off. And I look forward to having that debate in the future. There are a couple of folks on here that I think are no-brainers, others a little bit more difficult. So with that, Mr. Vice Chair, I'd ask the committee for a favorable report. I'll let the panelists go and I'll stand by for questions.
Good afternoon. I'm Melissa Rothstein, the Chief of External Affairs at the Maryland Office of the Public Defender, and I urge you to issue a favorable report on Senate Bill 1095. At the Public Defender's Office, we have mixed feelings about home detention. On the one hand, it is still very much detention and has increasingly been relied upon for individuals who can and should be released on their own recognizance, as they are neither a flight risk nor a serious risk to public safety. However, we also know it is a valuable tool to reduce jail populations and encourage less restrictive alternatives when judges are not willing to otherwise authorize release. And with the program that covered the cost of home monitoring for indigent individuals, it has been an effective way for many of our clients to remain with their families at their jobs and in their homes while awaiting their day in court. Publicly funded home detention has been a game changer in making this tool more available, and sustainability options need to be identified and explored. The recent depletion of federal funds underscored the importance of having a work group to examine this issue. While emergency funds are needed immediately, we also need a plan for long-term funding and sustainability and stability. A work group can also ensure that the program is cost-effective by examining options for private versus public monitoring options, as well as hybrid services that already exist in many counties, where some charges or qualifying factors are covered by county-funded monitoring, while others are eligible for private monitoring. Finally, the work group can examine the research and data from jurisdictions in and beyond Maryland to establish best practices. This would include identifying when monitoring is not needed for release and how to reduce racial biases in imposing restrictions. At OPD, we are committed and eager to be part of this work group and to ensure that Maryland's pretrial options are available across the state to everyone appropriate, regardless of their income, race, or county of residence, and that home monitoring is deployed equitably and efficiently. We urge you to pass Senate Bill 1095. Thanks.
Good afternoon, Mr. Vice Chairman, Senator Smith, members of the committee. For the record, my name is Mark Feinroth. I'm of counsel to the law firm of Boston and Plout. We represent some of the private firms who do the home detention monitoring. And we are very much in support of the bill. Thank the Senator for introducing the legislation. You'll note on page 2 of the legislation, we are represented on the work group. 2 members of the industry groups are included in the work group, but as non-voting members, naturally our group would prefer to be voting members of the work group. But with that amendment, we think it's an important effort, important initiative, an important program to continue, and we would support the bill with that small amendment.
Thank you. Questions for the sponsor or this panel? Senator West.
Thank you, Mr. Chair. I think this is the last bill of the day, and this is my last question of the day. Question for the spot. Question. Oh, wait a minute. I've only asked about 5 questions all day. Right. Yeah. So,
the man of the cloth said amen already. So
it seems to me this is a great bill, but right now we're facing a crisis. The judiciary's run out of money to pay for the home monitoring program. Is there something in your view that we could do of an emergency nature to get some more funding to the judiciary so that the program can continue for the rest of this fiscal year?
So breaking news, read the Daily Record. I think I was talking to counsel earlier. We were trying to identify some sort of a line item in the budget, and maybe we'd slide this an amendment into this bill, working with B&T. But I do believe that they have identified a funding source to get them through a temporary patch of time to ensure that the people that are currently enrolled in the program, like the 600 to 800 or so folks, whatever, don't quote me on the specific numbers, can remain, but they're not going to be able to take new folks into the program until they identify further funding. So I do think that there's a temporary stopgap that's been identified. I'm not quite sure where the money is. Maybe it's coming out of, I suspect, and I don't put me on record of this. This is, I'm guessing that it's coming from the budget, judiciary's budget, and then there'll be a gap fill afterwards in the next budget year.
Okay, great. Let's hope that we get it worked out. Thank you.
Well, yeah, I mean, we're gonna have to find, if we want to keep this program, especially for, I mean, obviously for indigent folks, and you want to have a two-tier system, we're gonna have to find a sustainable funding source.
Yep, that's right. Any questions, other questions for this panel? Now we'll go to Ms. Winchester, who's testifying virtually. Hello, Danielle, you're ready to go.
Good afternoon. Danielle Winchester, and the program director and owner of ASAP Home Detention. We support the bill. We feel as though the work group is essential. I think the only thing that we would look to add would be have at least one private home detention company on the work group. For instance, I have 29 years of experience doing specifically home detention. And I feel like I could be definitely an advocate for information.
Great. I know that was a point of debate last time when we had this bill. Any questions for Ms. Winchester? All right, seeing no questions, that concludes the hearing on Senate Bill 1095. Thank you, Mr. Chairman. Thank you to our witnesses. And that concludes our hearings for today.